Thank you.
My lord, COVID-like symptoms have taken a heavy toll on me. There is item 5, my lord, in today's list.
Yes.
Mr. Diganto Das is on the other side. I hope my esteemed colleague is very much present in the court. So
I'm
I
here.
had,
I'm
Yes,
in the
my
court.
yes, my lord. So I had a talk with him, and mutually, my lord, we have decided that 12th of August possibly would be an appropriate date on which this matter can be heard.
12th of
Because-
August.
Yes, 12th
12th
of
of
August.
August. 12th of August is the silver jubilee of the establishment of this
Oh,
bench.
9
So-
Okay, it may be
Like when it is possible, like after 12, anytime.
no
13th of
no issue.
No
Oh,
issue.
very well.
No issue. Then it's okay.
I'm
then
just
we will be
I'm
there
just
with
I'm
the
just, I'm
we will
just
be there.
apprising and just
Very well.
reminding.
Very well. We will
25th
be
years.
there. We will be there with the lordship to celebrate the silver jubilee.
If you agree.
Yes.
That's
12th
it.
August.
Yes.
Very well.
Okay.
Item 5.
Yes.
The who is mentioning? Who is seeking it?
Yes, so Mr. I think Mr. Anshuman Sharma is present in the court.
Mr.
I'm assisting, Mr.
Mr. Petitioner, learned counsel, learned senior counsel assisted by Mr.
A. Sharma.
S. Sharma, learned counsel for the respondent. Respondent number 1.
Yes.
Respondent number 1.
Yes.
Yes, yes. Yes.
Press that matter may be taken up on 12th of 12/08/2025. Mr. Prayer not been objected to by Mr. Didas, that is senior counsel assisted by Mr. Learned counsel for the appellant. Let this matter be listed on 12th.
There is an interim order which will continue.
Mr. 12/08/2025. Interim order passed earlier shall continue.
Deeply obvious.
May, Your Honor. Your Honor, I beg to mention item number 15.
15,
15, 15.
15.
Yes, 15 and 16.
Okay. You're for?
I'm for appellant, Your Honor.
15
Item
and
15.
16.
Yes.
Your Lordship, I am for the appellant for item number 16.
Okay. Now on the prayer of Mr. Connected matter,
16, nothing. Yes,
connected appeal. Mr. So and so learned counsel for the respondent,
No, appellant.
appellant. List this matter after 4 weeks. 2
2
weeks,
weeks, after vacation, Your Honor.
after 2 weeks, 15, 16.
Hello.
My lord, I beg to mention item number 18.
18.
Yes.
18.
On behalf of T. Jamal.
18 into 17, 18.
Senior counsel is out of station.
T. Jamo,
Yes, sir.
17, 18.
18, my lord.
Item,
Item number 18.
division bench,
Yes, my lord.
criminal appeal.
Yes, yes.
T. Jamo.
Yes.
Where is T. Jamo? His name is not there.
On behalf of complainant, my lord.
On the prayer of so and so, learned counsel for the respondent.
After,
Release this
my lord,
matter
after
after 3
vacation.
weeks.
Briefly open.
May, please.
My lord, it's item number 3, my lord. My lord, due to some my personal difficulty, yes.
What is there?
I could
Nothing.
I could not prepare.
What is to be prepared here?
My lord, there needs the argument, my lord. Because as on today, my LPC has not been cancelled, my lord.
It's okay.
That's why, my lord, I
Single,
need
single
some time.
bench, even if it's not cancelled,
Maybe
even you have, it cannot be allowed to pass through.
I will argue.
You argue, what's there?
Today, my lord, I have not prepared. I need preparation, my lord.
Sir, it doesn't need any preparation.
My lord, I need.
Matter is very simple.
Well, kindly.
Maybe you may be the owner of the single bench has clearly said you may be the owner of the, even if it's not cancelled. You may be the owner, but it cannot be allowed to pass through the wildlife sanctuary. It's correct. What's wrong there?
No, my lord.
We'll not go into that whether you are or not. That is under process.
That's why, my lord. There are so many issues are there, my lord. Findings by the learned single bench that
It's a 3-page
disputed question
order.
of fact, my lord.
Yes.
Regarding that the owner lies with, it falls within the wildlife sanctuary, my lord.
Yes.
I will demonstrate from those documents, all those things, my lord. It doesn't falls under the
You
wildlife
demonstrate today.
My lord, yesterday, my lord, could not prepare for. I could not go through.
You know that
Personally.
what are the documents?
My lord, kindly.
What are the documents?
No, my lord, I some time maybe. Immediately after vacation, my lord, I will not seek more time, my lord. I need at least one night to prepare at least.
It's not a new grant. So
My lord. I could not.
it's all as all those old grounds immediately after the vacation. I could not prepare. Come up with some new grounds. It's nothing actually. After vacation.
One time, my lord.
Mr. Arsona, learned counsel for the appellant submits that due to personal problem, he could not
My lord, yesterday.
prepare the matter for argument. Mr. Therefore, press for adjournment of the matter. For 2 weeks. 2 weeks.
So on
prayer
13,
not-
my lord, 13 August, I will try to.
Prayer not been objected by MS G at Learned Edison Senior Governor for the respondents. Come on. Let this matter be listed
On
on
13 August.
13.
30th of July.
No, July, my lord. 13th of July, it's a vacation.
No, it's
30th
the
of-
second week of the opening.
13th of July is the Sunday.
I said 30,
30.
30.
You agree that no issue. 12th or 30th or 13th.
Also, let it be after 2 weeks. Okay.
2 weeks.
My lord, some fixed date may be given August 13, my lord.
You agree what's there?
Lordship,
13.
On that day, I
13/08/2020.
Today also I was not consenting.
I will prepare.
Since
I do on that.
Are you constructing the road?
My lord.
Are you constructing the road?
No, my lord. My case is like
You are
that.
not doing anything.
No, my lord.
Are you doing anything?
No. How
Over
can I
there?
do? I sought the permission to allow me to undertake the construction.
Ah,
So road construction.
That has been
So that was denied. That's why that denial was put into challenge.
okay.
My lord, no stay, nothing. As on today, land is there as it is only.
You cancel the LPC.
My lord, in the meantime.
In the meantime.
they will come again because it's pending, they will
You
stay.
cannot stop them.
That's
Cannot
the thing.
stop
That's the
the
difficulty.
citizen to
Lordship.
come to
And my lord, the
process.
land they are saying, even I think if the way they have projected the wildlife sanctuary, even this area also falls under wildlife
Okay,
sanctuary.
okay,
My lord.
13.
13.
In the meantime, whatever you want to do it.
Much obliged.
Okay.
Yeah, and I'd like to mention item number 13. I mean, item number 4,
Item number 4.
yes, on behalf of Taba Targum Standing Council for Education Department.
Adjourn. You record his name and
Some habeas corpus application, your lordships.
Before my learned friend starts, Lordship, the PPs should have been a party. For IO, I cannot, Lordship.
it's all right, no issue. It's a habeas corpus.
Lordship.
The writ petitioner's sister, your lordship, she has been behind the bar on 22/4/2025. She has been arrested from the Samastipur, Bihar, in a one case which has been registered under 0 PS case number 08. The lady, she's a homemaker having 3 minor children. She has been arrested, and subsequently this honorable court granted bail on 29/5/2025. On that very day, at around 6:15, for 5:30, one FIR has been lodged against her. in the impugn FIR, your lordships, if your lordship kindly go to the entire material, she has been not in a whisper has been made against her. There is a monetary transaction has been misappropriation of monetary transaction, which has been reflected that is
That
her
FIR has been registered.
FIR has been registered.
So-
The lordships, the impugn FIR does not reflect the involvement of her, the petitioner sister.
It's a,
So, lordship.
it's a good ground to apply, to approach appropriate court.
No, lordship. The second, your lordship, after that 29.
It's not a case
No,
of-
lordship, no. There is a ground for violation of Article 22(1).
It's
Because
okay.
she has not been produced before the
Sir,
learned.
we understand. It's not a case of habeas corpus.
No. There is a blatant
See,
violation.
you have been arrested. I mean, your sister, the accused has been arrested in one case.
One case.
Bail was granted.
Bail was granted.
There's no issue. There's no issue.
No, there is no issue.
There's no denial of the, I mean, she was supposed to be released.
No, there is
Right.
no. But subsequently on very day,
Has the bail order been violated?
no, there is no violation of bail. No.
Then next, there is another case where you have been arrested, where your sister has been.
Arrested, the ground
arrested.
of arrest has not been, kindly, ground of
You
arrest.
approach, if the FIR doesn't disclose anything against you, it's a good ground for bail.
But the violation of Article 21, she must be produced before the
Uh,
24
It's not
hours.
in all the cases, can we stop from registering a case?
No,
And
I'm not going to register a case. I'm
see,
concerned.
you have maybe a similar facts, similar allegation, but different person.
No, the one thing is that
No, it's not a case.
no,
of habeas-
lordship. Kindly listen. I am violation of the Article 21. She has to be produced before the,
Sorry,
she has to be produced before the, within the magistrate within the 24 hours.
that is you approach the appropriate court.
No,
Will look
that is
into
why
it and or you file appropriate application, not the habeas corpus.
No. I have filed these are letter of the decision of the Honorable Apex Court onward that she's a blatant violation of the
You may file a criminal petition. We're not supposed to make you wise. We are not here to schooling you, right?
No,
You
yes,
are a
lordship.
lawyer.
But the thing
Sorry.
is that no, lordship, kindly allow me to submit one point, your lordship.
There's nothing, no more point. Your this thing, your sister has been arrested
Lordships,
in
Lordship.
another case
lordship.
filed by another complainant. What's wrong?
No,
If there's
we-
nothing against you, you approach the.
No, she
appropriate
has
court.
not been produced before. No, number one is she has not been produced before the learned judicial magistrate within 24 hours.
See, we'll just issue notice, nothing else.
No, lordships.
It's not a case of habeas corpus. Sir, try to understand. My sister and myself happen to practice with a senior
Your lordship. But the thing is that
since 1998
No.
who mostly deals with the habeas corpus matter.
no, the thing is that I appreciate your lordship's point. But thing is that there is a
I'm
constitutional.
not sure about me, but
No.
my sister has it in fingertips.
No, but since she has been
Sir, it's not a case of habeas corpus.
lordships.
Withdraw, file a appropriate application. It's
Lordship,
better.
then we have to withdraw and file an application. No, but thing is that
We'll give you a liberty to file appropriate application.
then thing is that another point.
Heard Mr. So and so. All right,
Lordship.
or anything.
Lordship, this another 20% are waiting for lodging a similar kind of affair. That is the bigger issues.
That's what I'm saying. Who is stopping you? You approach, you file an appropriate
Lodge.
application before the appropriate appropriate application under the appropriate provision, not the habeas corpus. We understand.
But the
That's
arrest.
why initially we asked you whether you have been granted bail in the first case.
Yes.
We released on bail
Yes.
in the first case.
But thing is that arrest the procedure.
We understand, but there's a appropriate way of.
Lordship, we file an application.
Yes, heard Mr. H. Borwa, learned counsel for the petitioner. No, we'll say. Mr. H. Borwa, learned counsel for the petitioner, having realized that the issue, the grievance, the habeas corpus petition would not be maintainable, press for withdrawal of the writ petition with a liberty to file appropriate application. With a liberty to approach the with the liberty to avail the appropriate remedy.
Lordship, Lordship.
List of prayers allowed, writ petition stands dismissed on withdrawal with the liberty as prayed for.
Lordship.
Wait. What is that contempt?
And Mr. Deepak Lani, counsel for the petitioner. This is an application under section 12 of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India. And Rule 9 of the Contempt of Courts Guwahati High Court Rules to 1977. Alleging deliberate violation of willful and deliberate violation of the order dated 29/7/2024 passed in WPC 304 AP of 2020. Mr. Issue notice.
N9 4/2025 passed by this division.
N9
4/2025
2025.
passed in read appeal number 25 of 2020.
Writ appeal number 25 of 2025.
24. Read appeal
24. Issue notice returnable by 4 weeks. Let the counsel for the petitioners to take steps for service of notice after respondents.
Oh,
Lordship, in this writ appeal, Lordship, I'm being agreed by the judgment and order of the single bench, Lordship. Lordship, basically on 2 grounds, my writ petition has been dismissed. Basically on the 2 grounds saying that in the whole process, I have not controverted to the affidavits filed by the ITBP, whereby they have relied on to certain documents to show that the lane in dispute, wherein we have contended that that lane was not acquired and compensation being paid as per the latest Acquisition Act. And one more ground was of the doctrine of leches, Lordship.
Yes, you have already paid the compensation.
That amount we have, in fact, the state respondent also has contributed to that fact that the documents that they have annexed to show that the compensation amount has been paid, the state has contributed that, Lordship.
All are represented. All the respondents are represented.
yes.
Heard Mr. J.J. Learned Counsel for the appellants. And also had Mr. M. Kato Learned DSGI for respondent number
1, 6, 7, 8, and 9.
1, 6, 7, 8, and 9. And Mr. L. Long Learned Senior Government Advocate for respondent number 2 to 5. Admit list after admit since they respondents are duly represented by the respective councils, learned respective council, no formal notice need be issued.
Madam.
List on,
After 3 weeks, Lordship.
list after 4 weeks.
Obliged.
Number 7.
Madam, may I pray that, Madam, in this matter, Madam, as per the instruction of the Union Public Service Commission, Madam. In fact, Madam, the affidavit was sent, but that was defective. 3 weeks time may be granted. In the meantime, we'll file the affidavit.
Union Public Service
Yes,
Commission.
Madam.
This is the writ petition by Union of India.
Madam, however, Madam, the
You are appearing for
yes,
respondents.
Controller Auditor General, Madam, filed this.
Are you appearing for the,
I'm on behalf of NNJ.
for
Respondent 1.
respondent number 1?
Yes.
And which for respondent number 2? Selection committee, government of the Eastern.
Respondent number 2.
Are
is
you
the
for staff selection commission?
Madam. I'm protested.
Respondent number 2.
Yes, Madam. Respondent number 2.
You are for 2.
Yes, Madam. I'm for 2.
Heard Mr. So-and-so, learn concept for the appellant. Although office note indicates that neither the ID card nor unserved notice has been received in respect of respondent number 2, Mr. M. Kato. As learned counsel
Yes.
or DHGI.
Yes, DSA.
DHGI, you cannot. This is, how can you appear?
As per the instructions, Madam, this comes.
You appear as it's a appeal by the Union of India.
Receive the copy
Mr.
of Madam,
You say, you discuss with them, you may appear as but it also doesn't look proper. But today we'll record your appearance, but then
Madam.
think about it.
Staff Selection Board, Madam, committee, Madam.
Yes. You discuss it and think
Yes.
about it, ponder on it. It doesn't look nice, but we're not recording you as a DSGI. DSGI, Mr. M. Kato, Mr. M. Kato, learned counsel, enters appearance on behalf of respondent number 2. Mr. And MS so-and-so is also present on behalf of respondent number 1. In view of the service is complete. List for admission after 2 weeks, 3 weeks.
There is an entry mode. It may be
Interim order process alerts will continue. You think about it. I'm
Yes.
not recording a learned counsel.
Yes.
That's, I think better you should not. You should not. You bring a DHA,
Yes. But Madam, as per the intimation given by the Madam.
but talk to them.
Yes, Madam.
Tell them. They may not know.
Therefore, Madam.
They may not know the
Madam,
nitty-gritty
Yes.
of the profession.
I refuse to, Madam, accept on notice on behalf
Talk
of.
to them again.
Yes, sir.
Today we are receiving. Let's ask them to engage some other lawyer.
Much.
Yes.
Your Lordship, here respondent number 4 have filed the affidavit in opposition, rest of the affidavit in opposition pending.
When did you take steps for 5 and 12, 6, 7? Heard MS so-and-so. We wait for some time.
Yes.
Learn consent for the petitioner. Petitioners,
Yes, a petition.
1.
Yes. Yes.
1 petitioner. And MS. Deepangu for respondent number
2, 3, and 4, Your Lordship.
2, 3, and 4. And who else are there? Nobody. 1, 2, 3, and 4. And office note that is 020725 indicates that no ID card or answer notice has been received in respect of some number 4. List after 4 weeks. Awaiting report.
My father.
Yes.
Find the status report.
Who is for, yes. Dubeji.
And I'm sorry, I could not personally appear not because of some previous engagements.
Yes,
Lord, but,
where is the status report?
Lord, we have filed yesterday.
Status of
Lord.
the work.
Yes. Lord, there is a direction of the lordships by which, Lord, we have to file our reports bi-weekly, Lord.
They filed it, my lord.
They filed it. It's,
Yes.
where is this?
Every 2 weeks is coming up, so there are small progresses are there. Some works are going on.
At least.
Yes. I
Yes,
wish
my
they
lord, because
do the
lordships
model
did
village to the usually part. I don't know why, but they are just not touching it.
Where is the status report? No, latest one.
Signed on 2nd of July.
17-6. 17-6.
No,
Yes.
my lord.
No, no, no.
Not 17.
Yesterday, second
Yesterday.
Huh?
2nd
July.
No, report on field survey.
That is by the advocates group.
Okay.
1760. It starts from page number starts from 423
Okay.
457.
423. Okay. No, we have only up to 422.
No, I don't know. I have been furnished a copy. I don't know if they have filed or not.
Okay. We'll say that there's a improvement in the work and
I don't know if it would be the right word. They say there is some progress, my lord. That I don't know why they are not taking up that portion of the road. Model village. So I've been harping about it all along. It is totally damaged now.
which portion?
Kankardala to Nirjuli, my lord. There should not be any difficulty, my lord, about it. There is something they don't even reply. I don't know why. Because there have been directions from this honorable court that they should start work on that also. That part, my lord, there is absolutely nothing. They are not doing anything. This package B actually is from near Naharlagan to a place called Nirjuli. It's around 10 kilometers from here. So around 3.9 kilometers there is in between the townships. So there may be some encumbrances, some difficulties going on. This project was supposed to be completed on 7th of December 2024. Now, from a place called Model Village up to Nirjuli should be around 6 to 7 kilometers. There are no encumbrances there. That part, there was some work earlier. It has been totally damaged now. No, they are not doing anything about it.
Yes, whatever the package B.
My lord. Lord, it consists of the road as well as bridge, my lords. What my learned
Yeah.
friend is saying, Lord, he's right. When Lord, what has happened there in Lord, so far as the main construction of road is complete, with the carpeting and DBM things we have not been able to do. Lord, some portion it has been done, but because of the rainy seasons, Lord, the emphasis is on the maintenance. If your lordship would see, Lord, we have indicated also, Lord, last few days, Lord, what kind of rains we have. So, Lord, once Lord, this, because once we do it the DBM part, then again it's been washed out, Lord. That is the difficulty we have been facing all these days. Lord, my friend is correct when he's saying, Lord, that part, Lord, because that the construction part and some part of drainage has also been done therein. Lord, there also there is no hindrance. But if we do DBM part at this stage, Lord, it gets washed out. Lord, that's the difficulty we have been facing. My lord, we have also tried, my lord, the committee report was given last occasion, my lord. We have also responded to that, my lord. We are also looking into that and my lord, trying to work on that aspects, my lords. And then report also there was, my lord, regarding some drainage, my lord. Some part of this was not within the scope, my lord. We have also tried to clarify. My lord, if your
Yes,
lordship permit, my lord, next date is fixed on 24th, my lord. I'll be
Well, I have physically seen it what is happening. Drainage, in Nirjuli part also, right near the Bagatina, there is something being done. Only that part.
Execute.
Yes. Not completed. They have just dug up the earth.
Do you have the status report?
Only on Monday night I saw it.
Yes. Do you have the status report?
Yes.
Come to para 4. Hindrances,
Yes.
page 40.
Hindrances are, I've been instructing.
Unshifted utilities at multiple locations.
That we have already asked the Deputy Commissioner. Approach the Deputy Commissioner, wherever their requirement for shifting the utilities, it's being done. Apparently, there are some hindrances, which the administration has, it appears, has not been doing anything about it.
And para page 436 also. Para 5.
This also, my lord, is correct. On the left hand side, if we go from here to the right hand side, it is because of the silting.
That's
And
the reason we asked them to sit together and work it out.
Yes, madam. They should do it. This is correct, in fact. If it is not stopped, even if it is constructed, supposing in the winter, by next summer it will go again. There's so much silting, so much illegal art cutting going on. In fact, the executive engineer and the new deputy commissioner, they have visited all where the hindrances are there. And these are being taken up, madam.
You also file status report.
Let
Next.
them also file.
When
Yes,
you go
hindrances,
for-
what they are
direct
doing.
them to-
Yes,
direct
in
them
response to this, yes.
uh,
Silting will have to be taken care of. Otherwise, the way the art conditions are in this area, it will, no point.
Heard Mr. Deepangi, counsel for the petitioners. And Mr. And Ratan, additional advocate general for the state.
I'm for respondent number 6, madam.
And Mr. Dubey for respondent number 7.
yes, ma'am.
In terms of the order dated 0805/2025, passed by this court. Next man, respondent 7 has filed the status report. Where is the status report? On such period, we find that there's a little improvement in the execution of works. conflicted. However, certain hindrances. No, however, the respondent public public contractor has placed has appraised certain hindrances which indicates the related to unresolved site related issues, i.e. pending disputes, unshifted utilities at multiple locations, uncleared and undemolished structures, and insufficient formation white WITS weight in several stretches. It also indicates certain hindrances indicates site encumbrances, including electric poles, water pipelines, private properties, etc., which have not been removed yet from the site. Considering above, we deem it appropriate to direct the state authorities, particularly
Deputy Commissioner.
authorities in the concerned departments. What would be all the departments
Departments and the deputy commissioner, my lord, the district administration.
and the deputy commissioner to take actions as expeditiously as possible, so that the execution of the work could be, so that the works could be smoothly. The execution works could be smoothly progressed. Mr. The parties, including the state respondents. No, the state respondents, as well as the respondent number 7, to file the status report on the next date.
My lord, may I kindly, they have stated in their hindrance, parking between the pillars. That is the problem.
Action taken and the status report on the next day. And the respondents are directed to, what is that order, last order?
For fixing date, my lord.
No, this way. The direction, the observation and direction made by this code in the on 19/06/2025 is are reiterated. That's all.
Yes, this is to come up on 24/7.
List the matter on 24/7. Yes, Dubey, you will have to furnish you file the status report on every, I mean, on next date also.
Hindrance that they have pointed out regarding parking, that is a fact. I have personally seen they're now starting working at night. Yes. So since they're parking in between the pillars, they're finding it difficult to work. There are cars in between the pillars, they're parking the whole night. That is difficult.
It is the deputy commissioner.
The deputy commissioner to look into it.
indicate departments to take.
Yes, deputy commissioner ICR.
I share her.
Deeply obliged, my lord.
Obliged, obliged.
Your Lordship, I'm seeking some more time. Lord appears for the petitioner. Applicant on call. Next para, Mr. Ivan London, counsel for the respondent, opposite party. For respondent, seeks for further 2 weeks time to file objection. This price allowed. List after 2 weeks. What is this? Yes,
My lord, Mr. Kane Chaudhary is out of station, so I am appearing on his behalf, my lord. My lord, I have gone through the entire matter. I felt also that what your lordship has observed is very disturbing. I have seen that. And I have seen also 4 things I want to point out before they start. I think this particular writ appeal should not be entertained at all. What is the ground of not entertaining? I will explain to your lordship. Please look into the affidavit that has been filed by them. It's very unfortunate. See the affidavit and learned single judge. It was not with the mind of the learned single judge. Kindly see the affidavit in reply which we have filed against. We file an IA for vacating of that order. They file an affidavit in opposition. We file a reply. If your lordship looks into the reply at page 38, kindly see at page 38.
Just wait.
Yes, I'm yes.
Yes, you still left in it.
Finally, what an achievement we have directly Yes.
My lord, the first point which I like to address before this court, it page 38.
Of IA.
of the IA, yes,
Ah.
affidavit in reply which we have filed.
Hmm.
If you see at page 38, my lord will kindly see on the right hand side, the sign of Mr. Raja Pau is there.
Hmm.
He is repenting respond number 5.
Hmm.
So he is not a person aggrieved
Hmm.
unless it is by way of a power of attorney which can be executed. Legally, power of attorney. I'll show one judgment of this court. What is that power of attorney? How legally he can appear in this case. Otherwise, he doesn't have a leg to stand. Raja Rao, my lordship has seen first 38. Now kindly see in his writ petition, he appeared as respond number 5. Kindly see the wakalat number. No allment this men so and so appoint name respond number 5. He is not a bidder in this case, Raja Pau. Now, if you see, my lord, the affidavit. Now, this affidavit in the writ court, if you see the writ court affidavit filed by Raja Pau itself. See at page 4 in the appeal. Kindly see the appeal now. 422. Kindly see the appeal for a moment. 422. 422. Lordship got it? It's 422 of the appeal memo. This is the writ petition 615. It is affidavit filed by Raja Pau. Now, authorized representative of so and so. Now, it has been signed by him. So, what is that authorization is kindly see at 431 now. Now, this is, he said, they authorized Raj Pau. Now, see at 431. This is what he projects, authorization. I see so and so, where so and so, do hereby solemnly affirm and declare a note as under I authorize so and so, resident to represent my firm in legal matter of work, namely so and so, so and so. So, is this enough? I'll show you that this is not enough. That can be, this is an authorization in respect of some legal matter of the work. So, my lord, the learned single judge, with great respect, my lord, if this would have been looked into it, my lord, it would not have entertained his appearance before the court as a respond number 5. This is a very serious, my lord. So, on what count an appeal has been filed? On which ground he's aggrieved? He's not an aggrieved person. Aggrieved person has to come and he would have represented this matter. He's not representing this matter. Someone, Raj Pau, is representing this matter. Number 1, Wakalatnama he signs. Wakalatnama is not signed by the proprietor. And neither it is bracket the power of attorney holder. Nothing is there. Second is that, my lord, see one affidavit has filed with Raj Pau, what knowledge he has got. And on the basis of 431. And if the learned single judge, my lord, would have known, my lord, in this count itself, it should not be entertained. This is one of the instance I am showing, my lord, before this court. One of the instance. Now kindly see when this yes, yes. Now, this is one of the instance. Now come to second instance, my lord. My lord, these what may say, I am prepared with the merit of the case. But these I am showing because I have gone through entire proceeding. And I have seen, my lord, as we also as a senior counsel, we should be also responsible in all matters. Winning and losing is a part of it, my lord. That's why you rightly has pointed out, we senior has to be more responsible. My lord, we believe by words and mouth, of junior counsel who assists us, some instruction, your lordship takes into gospel truth what we say. Sometimes your lordship doesn't look into the papers also. Now see at page 43, my lord, see page 43. What is the statement that is made? See 43 of my affidavit in opposition. See 43 now. The affidavit in reply, which I have filed. See at page 43. See 43.
Writ petition.
Yes, no, the of the affidavit in reply, which your lordship has just looked into it.
Appeal or what?
Yes.
In the
IA, my lord.
'43.
43. If you see at page 34, we made a statement. Page 34, we made a statement. In the writ appeal bears the name of Sri so-and-so, proprietor of Messe Tenjing Construction, appears in two places, one in Wakalatnama and one in affidavit in opposition. The two handwriting are totally different in the face of it. It is a clear case of forgery. If you see at page 43, see page 43, this is what they say, that is the signature of the appellant. Now, if you see the affidavit which has been filed, in this case, we sit at page 48, it starts at page 59. Kindly see. See page 59. See page 59 now. And kindly see that Wakalatnama.
E is different.
Yes. So, but that's my lord. This is just pointing out, my lord. I thought that I should point out before the court what is happening. Merit of the case, of course, I'll give a reply to it. But I think that this writ appeal should not be entertained if this type of things are happening, my lord. So this is number two. Number two. Number three, my lord, will kindly see. This is what at page, if you see, at page 65, page 81. Itu di now. Then number three, your lordship was worried and said, we want to see the conduct. That's what I have seen the order. You want to see the conduct. Now you see what they have done. That is why more worriedness was there of the court. If you see at page 81, see at page 81 of the reply.
Power of attorney.
Yes. Now see special power of attorney. Because only to cover up that 431, they know that doesn't have any validity law in that eye of law. So to cover up page 81, they brought the special power of attorney. And you see special power of attorney is before an executive magistrate. See, my lord, executive magistrate. Unless it is registered either by an authorized, it is registered, or before an appropriate authority being the government by the state, before the registry or before go to the deputy commissioner, there is a sub-register where a power of attorney is registered or a notary, notarized, duly notarized. So on this, my lord, kindly see, and which is more disturbing is when an certificate was issued. Your lordship, just recollect, a certificate was issued that 74% has been completed. Now that What the authority, the engineer said, no, sorry, it's a typographical error. So I'm withdrawing the letter. So substantial, before an appellate court, he praised that a substantial progress has happened. So on this ground, being a public interest, what we will do, yes, we have stated, or the honor of the learned single has been stated. Today, the effect is that, with great respect, a person, a bidder, who is not qualified also, somebody comes and respond on 5 appears, but the court also is not aware of it. Had the court been aware of this, that order would not have been passed. Court said that, okay, you have worked it, so whatever work you have done it, payment will be made to you. If this thing the court would have been aware that somebody else is filing this case, some Rajpao is filing, and he doesn't have any authorization letter, this is authorization cannot be treated. And see one more judgment, I'll show it, I will just connect the judgment with that. Yes, please look into it. See that, my lord. See now, my lord, paragraph 9. 9, no? See, this is a judgment of a division bench that to Itanagar bench, my lord. Lordship,
what is the citation?
Citation is 2015 5 GLR page 147. But this is a division bench. Actually, it is Honorable Justice B.K. Sharma and Manojit Bhuya. It is only Manojit Bhuya names is reflected, but division bench order. If you see, my lord, paragraph 3, facts, if your lordship permits me, my lord. Lordship got it? Only 2 paragraph 3 and 9 kindly be looked into it. I just read, if your lordship permits me to read paragraph 3. Yes. By the said undated authorization letter, the appellant was only authorized to collect, receive and submit tender documents on behalf of Messrs. Locum Brothers. In the course of hearing before the learned single judge, Mr. Nabam, learned AAG Arunachal seriously questioned the locus standi of the appellant, submitting that the appellant is not an aggrieved person and no power of attorney have been issued by Messrs. Locum Brothers in favor of the appellant writ petitioner. As such, the writ petition was not maintainable on the account of lack of locus standi. According to Mr. Nabam, so and so, the appellant has no authority to institute a legal proceeding on behalf of Messrs. Locum Brothers. The said objection raised by Mr. Nabam, learned so and so, was duly considered by the learned single judge on the material available on record, and by detailed judgment touching upon the basic facts and the point of locus dismissed the writ petition by judgment order dated 7/5/2015. Now, if you see paragraph 9, my lord. That I don't know who is person aggrieved, that all has been said, who is a person that has been discussed. See paragraph 9. Before this court, the court learned counsel appearing for the appellant has produced a photocopy of an undated general power of attorney alleged to have been registered on 15/1/2015. The authenticity of the said general power of attorney has been seriously objected to by Mr. Nabam, learned so and so. It would be worthwhile to mention bare perusal of photocopy of general power of attorney produced by so and so. Learned counsel of the appellant do not appear to be a document registered before an appropriate registering authority as required under the law. In fact, the said power of attorney did not indicate as to on which date the same was executed. It would also be worthwhile to mention that the power of attorney now produced before this court was not produced before the learned single judge. So that's the end of the matter, my lord. Neither this power of attorney was not produced, even that is not a legal document, which now they have produced because the court was worried of it and the court said, we want to see the conduct. Now his conduct is this by bringing notice to the court about a special power of attorney executed before a magistrate. And that did not file this power of attorney before the learned single judge also. Appropriate registering authority. So now, my lord, now what is about, my lord, the appeal? This is what I want to point out before this court. These are the 4 points. And secondly, let me tell about me now, my lord, about the notary part. That also I have to tell your lordship that there is a affidavit which has been filed before a notary. That is what they are in particular. That is not a genuine document. They said it cannot be treated because my particular party has not signed the notary before the notary. He has not gone and signed it. So that my learned friend is right. He said it cannot be treated in the eye of law. That particular document. Yes, that is correct, my lord. Let me sometimes we have to admit that my learned friend is right. My lord, your lordship was expressed some notary. These are our counterparts. They are the lawyers, my lord. We have to also teach them certain things, my lord. Because I also know, my lord, sometimes we call notary at our home when the clients are also there. But there are certain proper procedure. It has to be oath. It has to be registered. So that's part what I am saying that to that extent my learned friend is right. But what about all this, my lord? Now this is what the learned single judge, my lord, will kindly see. If your lordship wants to hear on merit, I can argue on merit also, my lord. Now these are that whether, my lord, we have asked for IA for vacating of this order on this count. And if your lordship, because what percentage of, suppose 90% of the work is...
Keeping that aside, we have passed so far as the interim murder and all these things are
Net is getting. Net is getting demanded.
open the maintainability of the writ appeal.
Yes, I have not seen. No, I have not seen that. I have not seen that because I don't want money. It is your lordship can look into it.
Yeah.
For an example, let us say that percentage of work is 74% of the work or 80%. What is that work? That work is what? Suppose today, if your lordship finds that writ appeal is, I can argue on the merit. On merit.
The direction of the single judge?
No, that is direction of the single judge is that, my lord, that order of the particular which has been given to the private respondent, that should be set aside. And whatever work he has done, that payment should be made. And secondly, who is the L1, that work should be given to him. Because either in course of argument, what I have seen, the learned single asked the petitioner, where I am representing as a respondent in this case, that what is your rate? He said, my rate is lower than the rate which has been submitted by the respondent, private respondent. My rate is much more lower. So court said, yes, question of revenue is also involved, public exchequer is involved. So whatever remaining portion, you will do it. Rest, whatever has been done, we will not stop, let the payment be made to him. And secondly, my lord, I am saying very quick, my lord, with 5 minutes, my lord. 3 points which my tender was rejected. 1, 4.4b1, clause 4.4b1, clause 4.4b2, and 4.7.1. 4.4b1 relates to giving a list of equipments, machineries, and 4.4b2 is key personnel has to be given, provided to them. Now, this was provided to them. Now, when they opened the technical bid, they rejected. Simple, there is no reasoning for rejection. They said, these are 3 particular clauses where you don't qualify it. On the basis of that, we are rejecting your bid. When we challenged it before the learned single judge, we took at a point that similar NIT was floated by the same department on 28/10/2024, where we participated. This is the same list, equipment, machinery was given, and you have allowed. How can you now not allow this particular in this NIT? You could have allowed because same list, machinery same, plant is same, key personnel is same, you have allowed. But you are not allowing in this. How you are not allowing it? That was accepted by the learned single judge. More so, they want to improve it by filing an affidavit before the court saying, no, there are certain invoices which you have given, invoices, so far as machineries are concerned. So these are, we doubt, there are some forgery. For learned single just says, can you improve your case by filing this particular affidavit? Then Mohinder Singh Gill and one of the judgment was taken into account. And they said, no, you cannot. This is a public order was issued. Now you want to improve your case. Next, 4.7.1. 4.7.1 is related to some information to be given. So they said there was a misrepresentation, information was not given. Some pending case, some performance. Now, what he said, this is only ground. Now, we said there were cases against the respondent number 5 also. They have not mentioned. Now, the contention what they have raised is that being a respondent is not required. Being a respondent, it is not required. That was the contention. Now, the learned single just said that how it can be. Being a respondent, it is not a case that then there will be a violation. Your lordship knows Dayaram Shetty will come. So you cannot now say that no, what we'll do, we'll leave so far as the private respondent is concerned. But this will be 4.71 is applicable to you. So that point was also negated by the learned single judge. All these 3 points. If you see at page 394, my lord, 394 of the judgment, your lordship is saying that what is the operative portion of the judgment? 394, my lord. (394), my lord. Paragraph 28, my lord. 27, my lord. Page 27. This court has also made a specific query to the petition regarding the price offered by him, and it appears the price of the petition was lower than the contract amount which was offered by the respondent number 5. The said query was put so to ensure that the present exercise of adjudication does not become a futile exercise. In view of the aforesaid facts and circumstances discussion made above, the court is left with no other option but to interfere with the impugned order dated 28/10/2024, by which the technical bid of the petitioner was rejected. Consequently, all consequent action, including the issue of letter of intent, work order in favor of respondent number 5, stands interfered with and are accordingly set aside. Remaining part of the work is to be assessed, and the same is required to be allotted to L1 bidder who is found eligible in accordance with law. It is, however, made clear that so far as the work done by respondent number 5 in the meanwhile is concerned, there will be no restriction towards payment and release of the bill to the said respondent number 5. So a balance also has been maintained. If this would have been known that some Raj Power has come in 5, then I think this order would not have been passed. The learned single judge would not have passed also this the payment.
But that was all before the learned single judge.
I'm sorry, my lord.
That was before the learned single judge.
I know, but
All
that's
this
a what.
affidavit and everything was
No,
there.
no, that is what I am just pointing out, my lord. This is what is a continuous process. A writ petition is a
When the
continuous
techni-
process when
when
appeal.
the technical bid is,
Appeal.
see, when the technical bid is rejected,
Yes.
but the question of asking for what is the financial, what is L1, what is the amount of the contract and all those.
Wait, I'm sorry, my lord.
Para 27 you have
Yes,
read.
yes, yes.
It ought not to have been, with the greatest respect.
No,
It's a challenge was against the
I know.
rejection of technical.
no,
bid.
why? Oh, my lord, that's my, I'll just tell your lordship.
Who has
why-
offered, what is the amount offered? I mean,
No,
that is
no,
something
that's
where
what-
I think we have gone much deep.
No, but whatever, my
unnecessary
lord.
into the matter.
Yes. I'm sorry.
In the contract matter, it's very limited.
No, I know.
It's
The
not
con-
all those, basically, these are a fight between the two contractors.
No, let's, my lord.
And in the process, these works get suffered.
No,
The public interest.
No, I know
against the
public interest, but if your lordship looks into it, the conduct, the public interest, the conduct has to be also looked into it, my lord. The conduct has to be looked into it, my lord.
That is another aspect.
Yes,
The
conduct,
merit-
if
when
your
you-
lordship.
when we come to the merit.
Yes, my lord, the conduct of a party has to be looked into it. Conduct of a party has to be looked into it, my lord. So maintainability, your lordship looks into the maintainability issue, whether this is maintainable at all. I just pointed out the merit in short, my lord. But your lordship is see the maintainability of the appeal.
Yes. Yes.
May it please your lordship.
It's
My
very
lord-
difficult through the via this thing. BC.
My lordship is absolutely correct, but possibly my voice is very clear to your lordship, and there is absolutely no hindrance. My lord, I'll be very short in indicating that this proceeding, my lord, your lordship is taking up here, the plea is delivered or repeatedly taken, is that about the maintainability of the writ appeal. My lord, the proprietor of the farm was implicated as a respondent in the case by challenging the rejection of technical bid by one of the unsuccessful bidders. Now, is the proprietor saying that I am not aggrieved by the any relief sought by the writ petition in the writ petition? Is he saying that I have not contested the writ petition? Is he saying that I am no? If my work order goes, I'll be happy. He has allowed the power of attorney holder to contest the case. The power of attorney holder contested the case. He has reaped the benefit. Today, my lord, under certain circumstances, an affidavit has been relied on. Fairly, my lord, my learned friend has now submitted that yes, that affidavit is wrong.
Just a second.
My
I think in view of the progress report, I think
My
we'll
lord.
fix it for hearing.
But my lord,
There's no option, including keeping the maintainability open.
no, one thing your lordship will kindly, my lord.
See, the
No, I
option-
understand.
Sir,
My lord, I
just
also
li-
understand.
Listen for a
Yeah.
second. The report indicates earlier it was 74. And we direct them to not submit the report by the last order you have said, superintendent engineer.
Yes.
Not the
Superintendent,
executive
yes.
engineer.
Yes.
Then the chief engineer constituted a committee and they visited and it's now report is progress is 59.79.
Yes.
So
I'll just-
It's a matter of 20 or 25
No, no,
days.
that's it. But
I said just only the permission cutting and everything, WVM and all this has not been started. Tomorrow, after hearing all, if you succeed, if they succeed, or if you succeed in the appeal, or in your favor, I mean, the similar order can be passed.
no, can I just suggest one thing? Subject to your-
Because the factual situation which has disturbed now is that at the before the learned single judge, nobody one is interested, right? And the authorized or whatever, a person has filed a writ petition. Might not be proprietor not interested, right? Now, right, when he has a chance to get the work, obviously he is rushed.
But that,
Today, at the appellate stage, we cannot say that the proprietor is not an, I mean,
no, that's
the
the
angry person.
My lord, I will
Now,
see, my lord.
we
I
last
can
on the
address
other
to the
sir,
court.
on the other day also we have indicated that the conduct of the appellant. Obviously, so far as the angry person is concerned, we may not. It would not be proper to say that he may not be a angry party, but it appears that he was not interested.
Who? I'm sorry, my lord.
Proprietor.
Proprietor, yes.
Therefore, it was represented by some authorized person or whatever, power of attorney, all that. In such a situation, I think it's better to
But-
go into the merit, keeping it
I'll
open the
yes, I'll
maintainability.
just tell you one thing, my lord.
Yes.
I just remember what your lordship is saying. We will note down those points. But the only difficulty here is that, my lord, that suppose today, I'm saying that whatever work they have done till 54%. But till your lordship hears the matter, let them not proceed with the work. Because that is no question of, because formation of art cutting only. Today is rainy season. So immediately, they will,
60% has been
otherwise,
completed.
what will happen? I'll just place it before the court. What happened tomorrow? If the 80% work is complete, so what remains in this case? Normally, that's the view of a court. But
They'll be
that's why my
compensated.
humble prayer.
We'll look into the
My humble-
this judgment.
My lord, my humble prayer before this court is that let whatever the status quo is on today shall be maintained. To that extent, because lordship IA, your lordship is IA, your lordship is hearing. Let a status quo is on today shall be maintained.
That will be stopping the war.
No,
That
my
will
lord,
amount to
formation of, my lord,
which you have.
my lord will,
we are not,
my lord will
would not
kindly
like to do
see.
it.
But today, if you're tomorrow,
Whether
your-
they works or not, but then
tomorrow,
it
if your
shows
lordship
that
finds,
works is in progress.
no, tomorrow, if your lordship finds that this is how a writ petition.
We'll apply the principle
No,
of
then what
this
remains?
judgment.
Then what remains? Then no amount.
Principle of this judgment.
No, then no, my lord.
It is. We look.
My lord, all the cases is
We'll have
depend.
to.
My lord,
We'll have to take care of the public interest rather
my
than
lord, all the
individual
cases
interest.
has to be looked
Either
into.
the appellant or the respondent.
My lord, all the cases has to be looked into facts of each case, my lord.
Yes.
All facts are not the judgment of a Supreme Court has to be in consonant with the facts of the case.
That is what with the best of our
That's
knowledge
what-
and ability.
No,
we're
no,
trying
my
to-
lord, I also, my lord, best of my knowledge and
Apply.
ability only I am
Yes.
saying, my lord. Not, but how can I say something?
So
my lord?
look at sir. Look at the public interest first.
Public interest
It's
will be
between
looked
you
into.
and-
Suppose
You want to do the work.
no public
What
interest.
public? If
Somebody
we stop the work,
tomorrow, if
is it
somebody
not
comes,
against the public?
no, I'll just tell. Well, a genuine person comes and public interest, then of course. Somebody doesn't, a genuine person comes, it is doubted a person, then your lordship will, with great respect, I am saying that there is no question of protecting by because of public interest. That's my humble submission, my lord.
No, that will consider.
No, that
We
is
have
what
not-
I am
we
saying.
have not yet
Tomorrow,
said.
if
We
it
are
is-
on the interim prayer.
No, that is why your lordship has said interim pair for modification, variation of the order to the extent is status quo, whatever work they have done, whatever they will continue.
It will
Rest they
amount
will not
to- It
continue.
will amount to stopping the
No,
work.
but you lordship will kindly see considerable days got an order of division bench is considerable amount of work has been progressed. Now they came with 74%. Today your lordship has seen what the report says.
69, 59.
So, how, my lord,
60%.
kindly see, wow, is this your lordship? My lord, I am just asking myself, my lord, this is what is they are trying to project. How they got
Sir, it's a matter of 20 days or 20.
No, 74%. No, tomorrow,
You
my lord.
decide the date for it.
No, your lordship then
Final
will
disposal.
kindly note down, my lord, one thing, my lord, that will be any particular work, then will be subject to further order of this court. That any work he has done, that will be subject to further order of this court. That your lordship, if he progressing also, that will be subject to further order of this court. That's nothing, my lord, subject to further order of this court. Any work he does it now, that will be subject to further order of this court, my lord. I think that will be no difficulty from your lordship's
No, it's
viewpoint.
not our difficulty.
No, that
We're
is what I'm
concerned
saying.
about the
No,
public
what
rather than the individual.
no, my
interest
lord,
of the,
what I'm saying, that
bidders.
will not, my lord, that will not prejudice the other side. That will be
It will
subject to
prejudice,
further order
man.
of
It
this
will
court.
prejudice.
Your lordship will
My
look
lord,
into it. Will be subject to further order
We'll
of this
say,
court.
we'll say the work in question shall be subject to the outcome of the writ.
No, for subject to further order of this court. Further to order of this court, when your lordship is hearing the appeal immediately after reopening it, then your lordship will keep this. Otherwise, the court will say that it is subject to further order of this court will be much more.
Subject to outcome of the decision of this writ appeal will say.
Yeah, that is always there, man. That is
No,
always
there. Don't say always. I am just always there.
It's always.
We'll
your
say
lordship
that much will, if they are always there, you cannot have any objection, I suppose. So we'll
my lord, only
we'll
only
that order.
my lord, only
We'll
one
keep the
submission I'll make.
maintainability open.
Yes, and
yes.
and it will be subject to further order of this
And
court.
keeping
Any
this
work,
IA pending.
yes, any work which has been
Right.
done will be
My
subject
lord,
to
only
further order of this
lordship
court.
will permit me to
This
make
is
only
what your
one
lordship, my humble
submission.
prayer is.
This has already been admitted. Appeal has already been
No, that
admitted.
I understand. Appeal is admitted.
So we'll pass the order in this appeal, huh?
Yes.
In the appeal.
Yes.
Heard
My lord,
Mr.
only one submission if your lordship permits me. Only one submission. My lord, learned single judge, while disposing of the writ petition, said that whatever work he has done, he will be paid for that. Now, today, if your lordship says something against that, my lord, they have not filed any appeal against that order. So they cannot make any prayer which goes against the order passed by learned single judge. That is my submission. My lordship will consider that. They have not filed any appeal.
We're not going to today. You just
My lord.
work out the,
My lord.
decide, choose the date for final
My
of the hearing after
My lord.
after 20 days or 25 days.
My
You
lord,
just
my lord,
provide
my
that the works in question shall be subject to outcome of the.
My lord, that is always there. Your lordship's ultimate
It's
order
okay,
will
but then we'll
prevail.
provide it.
My lord. Your lordship's order will always
Because
prevail.
we don't know. We don't want to say anything more than what is required. But then we are not happy the conduct.
My lord, their conduct in procuring an affidavit, I will not go deep into it, my lord. Today they are admitting that it's not a correct affidavit. And
And Mr. We're keeping it open, everything.
My lord,
Mr.
my lord, we'll argue again, my lord.
You are for appellant.
Yes,
I'm
he's
for the appellant, my lord.
And Mr. D. Majumdar, learned senior counsel, assisted by
T. Bhagan.
Mr. T. Bhagan, learned counsel for the appellant, and also heard Mr. D. Das, learned senior advocate for learned senior counsel, assisted by Mr. R.M. Dekka, learned counsel for the respondent number 1, public writ petitioner, and Mr. P. D. Tara, learned counsel for the learned standing sir for rural works departments. In terms of the next direction, in terms of the order dated 26/6/2025, Mr. G. Tara, learned counsel for the petition, learned standing counsel for Rural Works Department, place the copy of the report and the communication dated 01/07/2025. Next paragraph. Where is the report submitted by the Superintendent Engineer, Rural Works. Circle, what is this? SEPA. Itanagar. Which indicates that the overall achievement in the percentage of work is 59.79%. Next please. Having considered that the appellant is executing the work with a certain amount of progress at nearly 60% of the entire work, if the work is still, the public interest will suffer. It would be against the public interest. However, considering the issues raised by the applicant oblique petitioner oblique respondent in the respondent, we provide that the work in question shall be subject to outcome of the writ appeal. Mr. We make it clear that the maintainability of the writ petition.
Writ appeal.
No, maintainability of the. It's a basic is
Writ
writ
appeal.
appeal.
Yes.
Writ appeal, though this
We have a petition,
proprietor is there.
Yes.
Writ appeal oblique.
Yeah.
It's a continuation.
Yes.
Writ appeal, the writ petition oblique. The
Writ petition was filed by them.
And the continuation of writ appeal shall be subject to the shall be is kept open.
Kept up.
Kept open. As agreed to by learned counsel for the parties, list this matter on when you choose the date. Twenty-first. 21st.
Yes, man, let it be 20. Yes, man, yes. 21st will be convenient. Yes.
07/20/20. Right.
Second, my lord. 23rd. 23rd.
23rd.
23rd.
Well,
Yes.
let it be then. From my side, I only pray, my lord, either 21 or 24, my lord. 22nd and 23rd, my lord, some difficulty.
You please decide.
21,
24th.
24th. 24th.
24th, my lord. My obliged, man, deeply obliged.
Lordship,
Notice was issued.
this Lords, today it is listed for the first time.
Will issue notice. So, heard Mr. K. Lowland, learned counsel for the applicant. This application seeking condemnation of 88 condemnation of delay of 88 days in filing the connected writ appeal. Mr. Writ appeal against the judgment and order.
Judgment and order 3.
Where it
4/3/2025.
4/3/2025, passed in WPC
186 of 24.
186 of 2020. Issue notice, returnable by 3 weeks. Who else are appearing? Is there a private respondent is there?
Private respondent, no lawsuit. No private respondent.
So do you have any objection? Huh? 88 days.
88 days. Huh?
You think over it, we'll take it up on tomorrow. So since you are appearing, you will have to, if you have no objection, we will condemn the delay. What's there?
Yes, of course, lawsuit.
After some time,
After some time.
just go.
This is also lawsuit for condemnation of delay lawsuit for 82 days.
There is a private response.
Yes, sir.
So you should notice.
Yes, sir.
I had Mr. K. Lawyer, learned counsel for the applicant. This is an application under section 5 of Indian Limitation Act 1964, referring for condemnation of delay of 82 days in filing the connected appeal, writ appeal against the judgment order 12/03/2025 in WPC, passed in WPC 4707 of 2020. Issue notice to the respondent. One response, three
private
respondents. Issue notice to the respondents. Next para Mr. So and so, then council will take his steps for service of list after 3 weeks. Huh?
Much obliged.
Yes, Mr. DHJ. Any objection? 88 days delay. Would you like to file objection or will condemn the delay? Okay. Then issue notice, huh? As Mr. M. Katolani DJ, who is respondent number 1?
Union of India.
And Mr. M.S. Arbasar, London State Council, enters appearance except notice on behalf of all the respondents, no formal notice need be served. Huh?
And Lordship, I have a small prayer. Lordship, the respondent number 6 and 7 may be strike. He is not necessary, but inadvertently implemented.
Next date we'll see. Huh?
Because I have to give notice upon them also. Only to striking of 6 and 7. Otherwise, all are represented.
As submitted by Mr. K. Lowland, London Council for Deputation, applicant submits that inadvertently the respondent
6 and 7.
When has been erred at perceived respondent who in fact are not necessary parties. In view of the name of the respondent 6 and 7 stands struck off.
Deeply obliged.
Writ petition dismissed.
Deeply obliged. May I mention one unlisted motion subject to Malad?
Tomorrow.
Malad, I am having difficulty tomorrow,
Huh?
Malad, at 2 p.m. Malad.
Why? Tomorrow. What is the urgency?
Urgency, Malad, my own personal difficulty. There is no Malad. It is subject to Malad at 2 p.m. Malad.
Madam, I'd like to mention 3 matters for listing our admission on 24th of July, madam, and appearing as outstation counsel for the IOC.
May I, Your Lordship? Lordship, I beg to mention item number 22, Your Lordship. In this matter, Junior Government Advocate Yomi Riramir appeared in this matter. So he instructed me to adjourn this matter.
22? What do you want?
Yeah, 22, Your Lordship.
Huh.
After vacation, Your Lordship.
Why?
In this matter, Advocate Y. Diram will appear, Your Lordship.
Yes. You are pro petitioner.
No, I'm mentioning for item 11 and 12.
Mr. Pangin, 2019 matter. 22, item 22.
20.
Item, yes, ma'am.
Is making a mention.
I was also trying to in fact persuade the petitioner because he is not getting the job. At best, this is regarding appointment beyond advertised post. I'm also trying to persuade him to withdraw, but he's not.
He's ready to.
He is not exactly ready.
He wants to continue.
Yes.
And you have scored higher marks than those selected candidates in the written examination.
Yes, yes. That part, madam, I may not be pressing. It will be difficult.
Then, anyway, in that case.
This regarding, but there has been appointment made beyond advertised post. That part is also, that is also a challenge. Let it be after the vacation, I will see in the meantime what we can do with them.
As agreed to by learned counsel for the parties, let this matter be listed after 2 weeks.
Obelisk, Your Lordship.
Mayor, I will mention item 11 and 12.
Yes.
Here, Senior Advocate D. Majumdar is appearing for petitioners, so he.
Who's BC?
No.
Then?
After, on 24th of July.
On
24th of July, he's taking the time.
Okay. On the prayer of MS Learned Council for the petition. Your name is not there.
It's there.
Where
item
it
number
is?
11.
11.
Yes.
Okay. Learned Council for the petition. And prayer not being objected to by Mr. Yes, Akshay. And council for the response. List this matter after 3 weeks.
Lordship, on 24th of July, both the senior councils have given their consent. 24th July. Humble request, Lordship. Both the council on 24th. Public.
In item number minor 5, we have filed caveat petition. And yesterday it was filed yesterday, in fact, due to some defects on the matter. So that caveat may be also confirmed.
Caveat, have you been furnished with the copy?
The copy has been furnished to the Learned Council.
Okay.
I don't know. Yes. In and earlier the mentioned item, that is RSA, regular second appeal, and the name of the parties is Lipe Ete versus Srimati Ide Ete.
Second appeal before the court number 2. Court number 2. Second appeal, court number 2.
Yes.
Sorry. Please notice.
Yes.
Heard Mr. Deepak Learned Counsel for the petition. This is an application under section 12 of the Contempt of Court Act 1917, read with Article 215 of the Constitution and Rule 9 of Contempt of Court Guwahati High Court, page 1 and 2. Alleging willful disobedience and violation of the judgment and order dated 10/04/2024 passed in WPC 256 of 2022. Issue notice returnable by 4 weeks. Then counsel for the petitioners to take steps for survey. Notice upon respond numbers, sole respondents, so within 2 days. List up to 4 weeks. With this.
Please, Your Lordships, I'm appearing in item 3 for the petitioner. If your lordships would peruse the order dated 5th of May 2025, your lordships, this honorable court had directed us to move an appropriate application seeking impleadment of the necessary party. Your lordships, that application was duly moved and the amended memo of parties have also been filed. And yes, your lordships, and the state of Arunachal Pradesh and Ministry of Education of the center and the state, three of them have been made party, your lordships. So this matter was today listed for issue of notice, your lordships. There is no interim prayer as such, your lordships. By this petition, your lordships, we are challenging the regulations 3A, 3B of the UGC, ODL and online learning regulations 2020.
I think this will go to division bench. Division bench. This regulation is enacted under the University Acts.
UGC Act, your lordships.
Yeah, so this will be placed before the division bench.
Please, lordships. Your lordships, if the notice may be issued today, your lordships.
No, we cannot issue a notice. It should be placed before division bench.
Very well.
As per the High Court rules.
Please, your lordships.
Right? List before the division bench. When?
Your lordships, next week, if it is possible.
Next week, no. Another 2 weeks, there will be, partial working day.
Any date, your lordships, then.
On 21st.
21st of July.
Yes.
Please, your lordships. I am grateful. Deeply obliged, your lordships. My appearance may be recorded, your lordships.
No, when you say that it should be before the division bench. Anyway, MS.
Please, your lordships.
MS.
Yutika
why-
Pallavi, lordships.
Why Pallavi, Learned Council, appears for petitioners? List before the division bench. List the matter before the division bench on 21 so and so.
I'm grateful, your lordships. Deeply obliged.
My lord, matter pertaining to the NIT, wherein my lord is, while my lord the impugn order, while rejecting my bid in our bid in the technical, my lord, no reason has been explained. For what reason, my lord, we have been rejected.
Where it is?
Nothing has
Where
been
is the
explained, my lord, in page number 47.
47 is the rejection.
My lord, got it? In complaint with the order issued by the Commissioner, Itanagar Municipal Corporation, wide number such and such, dated number such and such, regarding the opening of the e-tender and the technical bid under the help ground of the 15th Finance and Fund Board convenes on 28 May 2025 at 13 hours in the office chambers of the Executive Engineer Part 1 IMC in the presence of the bidders and the representatives. During evaluation of the bid submitted by the representative bidders, the board identified inconsistencies in the certain bid documents, whereas some bids were found to be in compliance with the SBD of their following packages. These 2 packages, out of these 2 packages, we have also participated in the NIT process. And accordingly, consequently, the board has listed the bidder who has successfully cleared the technical bid evaluation as follows. These 3 firm has been declared successful. And rest were 2 firm, this has been rejected. Thereafter, my lord, since out of this, there was the e-tender. Therefore, my lord, we have also uploaded all the documents uploaded by the competitive bidders. And thereby, we have found a lot of the discrepancies on the part of these selected bidders. Accordingly, we have placed a representation before the concerned authority on 3/6/2025, my lord, whereby we have stated that there is a certain discrepancies, but despite that, our lacuna has not been explained. Thereafter, my lord, may I kindly come to page number 50, my lord. Despite of the serious representation placed by us, this is the final minute pertaining to the, my lord, financial bit.
Okay.
My lord, 50.
L1 is
In compliance with the orders by the Commissioner, Itanagar Municipal Corporation, IMC, by dated number such and such, regarding the openings of the bids and under the helps ground of the PIP Finance Commission FC, the board convenes on the 13th June 2025 at the 14 hours in the office of the Chamber of Executive Engineer Part 1 IMC in presence of the qualified bidders. During opening of the bid of the financial bids, the board found that one comparative statement in the bids of the firm. The following firm are found to be L1 severely abnormal, L2 normal, abnormal, and L3 normal. Against the following package as indicated above, these are the, my lord, that they are finding, my lord. And my lord, lastly, my lord, in the second column, rather I will, my lord, take to the lordship to the last.
50.
What they have. Yes, my lord.
Page 50.
Page 50 of the last paragraph. To ensure a smooth execution of the work, the board has rejected the bid clarification clarified as severely abnormal rejected, and the abnormal rejected under the provision of CPW 6, the clause 8 of the standard bid document, and all the instruction of the SBD at serial number 31. This bid had percentage number such and such, respectively, which appear to be impractical for the execution of the work under the following package as the mentioned above. Instead, the board has decided to issue the acceptance letters to L3 bidders whose bids have been deemed normal. So in both the package, this L3, which I arranged as the respondent of private respondent number 4, is the MSGM Enterprise. This is the final, my lord, selection of the board. The board has decided to issue the work order to the private respondent. Now, basically, my question is that since there is a certain discrepancies I have found, particularly of the, my lord.
You first come to how your technical bid has been rejected. Forget about the others.
My lord.
For the time being. To tell us how your bid should not be rejected.
Exactly, my lord. What our contention is that we have fulfilled all the, my lord, standard document biddings.
Unless you notice nothing else.
My lord.
All right.
My lord.
We'll see.
My lord.
Heard Mr. C. Modi, learned counsel for the petitioner. Petitioners.
My lord.
One or
two petitions.
Petitioners. Aggrieved of the rejection of the bid of the petitioner, this petition has been instituted challenging the minutes of selection board. The technical selection board
2nd June 2020.
Is it a selection board?
My lord.
Is it a selection board?
Selection
Or
board.
tender committee? What do you get it?
Is my lord selection board.
It's a board, madam.
Tender board, not selection board. Board.
Board.
It's a board. Selection board or what? Where
It's
do you
only
get it?
written board, madam.
Huh?
It's only written board, madam.
Tender evaluation board dated 02/06/2025, rejecting the technical bid of the petitioner and the minutes dated 10/06/2025 recommending the respond number 5.
4, madam.
Respond number 4. Pursuant to the NIT dated 22/08/2025 for the work of renovation of maintenance.
Sorry, respondent number 6. Sorry, my lord.
Respond number 6, huh? Respond number 6. For the works of renovation of maintenance of urban health and wellness center at 3 locations under Itanagar. Particularly, there are three packages.
2 packages, my lord.
Huh?
2 packages.
2 packages.
My lord.
Then it will be enough. Huh? This issue notice returnable by 4 weeks. You are for?
I am for respondent 3 and 5. I on behalf of
Since
Tagum Jam
MS
Standing Council of IMC, Itanagar.
the T1 London State Council and Mr.
Tagum Jam and Endoji.
So and so enters appearance accept notice on behalf of respondent number 1 to 4, 1 to 5. No formal notice may be served. Have extra copies, sir. Mr. Petitioners to take stage for service of notice upon respondent.
For respondent number 4, there's standing council, madam. It's 104.
Director of Environment. You are for?
I am for respondent 3 and 5.
3 and 5.
I'm for 1 and 2.
Then you said 1 and 2, 1, 2, and 3 and 5. Then to take a stage for service of notice, respond 4 and 6, huh? 4 and 6.
No.
So and so within 2 days.
Oh,
You are not asking for interim order.
my lord, since, yes, my lord, I have an interim order,
Okay.
praying for an interim order. At least, my lord.
You are not interested.
Obviously.
You are not pressing it, so we are not considering it.
Otherwise, my lord, since the lordship has already indicated other than issue notice. Otherwise, my lord, if this is the case in the first stage, if the impugn order is if interim is not granted, my lord, there is a possibility that the work order can be issued to the other. That
But
will-
say the
My lord, but my lord, on 10/6/2025, my lord, it was open, my lord. It was recommended, my lord. So maybe they have already issued the.
no, we'll say the work in question shall be subject to the no next para, considering the submissions of learned counsel for the petitioner and considering that there is no indication on what ground the bid of practicable of the petitioner is rejected, comma, the award of the contract, award of the contract shall be subject to outcome of the writ petition. There is no indication.
All right.
But we said we're not stopping it, subject to outcome, so that he is not on next day the matter becomes. I mean, it should not be in process.
We filed KVS in item number 5, this matter.
The acquisition is under which law?
Your Honor.
Under which law?
LARR Act, Your Honor.
2013. There is no provision
Yes, Your Honor.
to approach the authority. Section 63 or 64. You apply, you approach. The land has been acquired under, just give me 2013.
It was done under Your Honor, section 37, Your Honor.
So
Of
what
Land
is,
Acquisition Act.
have you gone through the provisions of this act?
Yes, Your Honor.
Yes.
Your Honor.
Do you have that?
Yes, sir.
Do you have the act?
Not right now, Your Honor.
Huh?
Not right now.
You are making you are filing a case reference to authority who has not accepted the award may by written application require the minister to refer the minister to the case. There is objection to the measurement of the land, the amount of compensation, the person to whom it is payable, rights of the.
Yes.
Section 64.
64.
You avail this. Will give you liberty because the land has been acquired under the 2000 this act only. Withdraw and file will give you a liberty. It's not maintainable. It's not maintainable, sir.
Your Honor, my case is that I had purchased the.
You read section 64, please.
Yes, Your Honor. I have
Then
already
if you
given the
read it-
representation, Your Honor. That is what I'm seeking for. Your Honor. I have given a representation to the Deputy Commissioner, Your Honor. Two representation, Your Honor. One dated 15.
No, you're representing something. You write you file an application, appropriate application.
Yes, Your Honor. I
For
have already
reference.
given.
For reference, sir.
Yes. I have already given, Your Honor, but that is not being accepted, Your Honor. That's why this
So
case. Your Honor.
how do we know where it is? Where is your application?
Page number 33, Your Honor.
33? 33.
Yes, Your Honor. And page 34 also, Your Honor. I have filed two representation already, Your Honor.
33 is what?
Yeah, my representation.
In regards to ownership beneficial land aid, Luruku. This is the reviewing the estimated to adjust the issue of land issue necessary motion to agency and that is saying this.
Your Honor, even the notice was also not attached at the notice board of the ADC, Your
No,
Honor.
it's not a question of this thing. Where the prayer for reference? Where is the prayer for reference there?
Your Honor, if you come to page 34, there is.
Necessary direction to agencies under this request is made to look into it and also for necessary orders to concern agencies such as Frontier Highway and also management before not to enter records or documents the names of the. No, this is not a reference. Cannot be. Obviously, you have filed a representation. You have to file a reference application. Then the deputy commissioner will not decide. They'll refer it to the authority under section 64. You file an application under section 64. It's just a representation.
Yes, Your Honor. The copy was duly served to the DLRS also, Your Honor. DLRS also was served with this application.
To whom?
DLRSO, District Land Revenue and Settlement Officer.
Who is the authority? Under this act.
Collector, Your Honor. Collector is the Deputy Commissioner, Your Honor.
अरे यार समझ में नहीं आ रहा है. Section 51. Section 51, there is an authority. The appropriate government shall, for the purpose of providing speedy dispute relating land acquisition compensation so and so, one or more authorities to be known: land acquisition, rehabilitation, settlement authority. I think there is an authority. There is an authority, government. Section, read section 65, 64. Your representation is to the deputy commissioner, not to pass some orders and to the authority, not this land acquisition, I mean, the authority under this act. So you will allow, give you a liberty to file an appropriate application before the collector, deputy commissioner, for reference under section 64. All right.
Okay. Right.
Yes. Okay. You withdraw.
Yes, sir.
Okay. It should be the
Yes, Madam. Section
correct
64, yes.
because, right? Mr.
Sai Kumar.
Learned counsel for the petitioner fairly submits that he may be allowed to withdraw this writ petition to avail the appropriate remedy before the appropriate authority in terms of the right to so and so, huh? Mr. So and so, both of them, huh? Who is one?
I'm for 1, 2, 3.
Mr. N. Ratan, Learned Senior, Learned Additional Advocate General.
I'm for the cleavage.
So the state and Mr. D, the M. Kato, Learned D is also are present and have no objection to the withdrawal of the writ petition with liberty. With liberty. Considering the having considered the provision of section 51 and 64 of the right to so and so, the prayer for withdrawal of the petition is allowed. And according to the writ petition stands clause on withdrawal with the liberty to the petitioner to avail the appropriate remedy under the provisions of so and so. Huh?
Number 6.
May your lordship. Your lordship, this is a writ petition filed for praying for directing the respondent authority to take precautionary measure for preventing damage and loss of life, and also for non-disposal of my representation. This is with regards to compensation, your lordship. Earlier, the land they had acquired, and while acquiring the land, your lordship, at Tato, under Siomi district, your lordship, the land was acquired. And while acquiring the land, they had said that they
heard Mr. So-and-so learned counsel for the petitioner. By filing this writ petition, the petitioners, how many? One?
Yes, one.
The petitioner has prayed for direction to carry out assessment for the probable losses of properties, gardens and gardens, etc. And for payment of compensation to the villagers of what?
Padusa village.
Padusa village.
Under Tato circle.
Under Tato circle in the district of Siomi. On account of project for construction of what?
Tato to Siomi, National Highway.
Siomi.
National Highways.
National Highway. Mr. The issue notice returnable by 4 weeks as MS G at the learned additional senior government advocate enters appearance and accept notice on behalf of
125.
respondent number 125. Where is this, Mr. Kato? No formal notice will be there, however, extra copy will be furnished to the council for the respondent number 1 to 5. Mr. You served a copy to Mr. Kato?
Sure, yes.
And then counsel for the petitioner to furnish a copy to the Leonard DJ for respondent number 6. Mr. And the further the petitioners to take a stage for solution notice after respondent number 7. huh?
Yes.
Next paragraph. Considering that the what do you want?
Your Lordship, I'm praying for assessment of the probable loss.
No,
and
it's okay. That
yes.
I've said.
Interim,
That
Your
will
Lordship.
consider.
I'm praying for interim, Your Lordship.
Interim will provide that the authorities, public the authorities as well as the executing agency shall ensure that the construction shall ensure that the life and property of the people of Padusha village be protected while no, what are the precaution? No, to shall take precautionary measure so that the people of the Padusha village are not and so that the life of the people of the area are not if affected, huh?
Yes.
Affected, huh?
Your
As per the provisions. This is for what? Using of what?
Explosive bomb blasting, because of which
As per the applicable, as per the terms of the guidelines for using explosives and the construction of the road. Explosive for construction of the road. Is that it?
yes.
It's in all other constructions also is used, but then in this.
We'll see. You
because this is
ensure that the
this-
precautionary measure may be
Yes,
taken.
yes.
That's
500
only that.
meters
Why
of-
not stopping it?
Yes, 500.
You're supposed to take that also.
Your Lordship, and one more prayer, Your Lordship. Even the water supply has been damaged now, and I have prayed before the Deputy Commissioner also.
Ensure, you
Yeah.
see,
Then not
you see it there.
Your Lordship, 500 meters away, the bomb blast, the Peebles has
That's
come,
why I said ensure that the precautionary
Obliged.
measures are taken as per the
at
guidelines.
least the explosive portion, Your Lordship, because they are going to that area is
Okay.
an okay portion. Deeply obliged.
Lordship, this matter may be passed over. The leading counsel is on the way.
What is the matter?
Matter may be passed over.
So, who is appearing?
N. Rama. N. Rama.
N. Karma.
Yes.
For some time.
Maybe, Your Lordship.
Hmm.
Your Lordship, this is a land acquisition matter.
Hmm.
Your Lordship, fact of the case is that order was passed on 9/10/2023 by the Deputy Commissioner for public hearing. Thereafter, my Lord, Your Lordship, our main contention is that there was no ground survey, no public hearing, and no award has been shown to the beneficiaries. Therefore, Your Lordship, earlier we had filed a writ petition, WPC 982025, wherein this honorable court had disposed the writ petition by directing the deputy commissioner to dispose of their presentation. Thereafter, your lordship, deputy commissioner passes an order.
Where it is?
It's
Page.
Your lordship, we have not enclosed the writ petition, but we have
It is not
enclosed the.
enclosed.
Your lordship may see the page number. Your lordship, see the page number 124, your lordship.
124.
124.
By whom?
By the deputy commissioner, your lordship.
Deputy commissioner.
Yes. Your lordship, see page number 25, which is a type copy.
125.
125. Your lordship, though the deputy commissioner has disposed of the representation, but the deputy commissioner very cunningly stressed only on one representation, your lordship.
Huh?
Your deputy commissioner has stressed only on one representation, whereas we have filed so many representation. As per the direction of this honorable court, there was a clear direction that representation dated 10 to 2025, along with subsequent representation should be disposed with a speaking order, your lordship. Thereafter,
you are challenging this order?
Yes, your lordship.
Okay, we'll issue notice, that's all.
Your lordship.
What are you claiming for?
Your lordship, we have not been made party to the acquisition process.
Why?
Are
you the owner of the land?
Yes, your lordship.
Then you file a section 64 application.
No, we should have gone under section 64, but we are not disclosed the award.
Then
Land acquisition award.
how do we?
Therefore, your lordship, we are praying
This
that
court is not a RTA commissioner.
Your lordship,
RT commission. You file an RTI.
no, your lordship, as per
That
the
has been
section,
rejected.
we even file RTA also.
We
but
have
as
not
per-
been given.
Yeah, we are not given.
We have not been given. You have not been given.
We have not been given, your lordship.
So you file an appeal. What's
Your
the
lordship, as per the
record?
section 37 of this Land Acquisition Act, which says that award detail has to be shown to the beneficiary.
That's why. That's why you file an appeal.
Your lordship, we have tried all possible ways where we can find RTI, but we are not.
RTI, if it is not provided, what is the next course?
Your lordship, I think,
Before whom you have filed an information, sought for.
your lordship, there is no need of going to the RTI commission because the section clearly says that, section 37 clause 2 clearly says that award detail has to be clearly shown to the beneficiaries or the land affected people.
What you are aggrieved? Are you aggrieved by not furnishing of the details?
Yes, your lordship, we don't know how much amount has been quantified for us. We don't know
Then
how
you
much.
file an RTI. See, give me that.
And your lordship, one more point is that some compensation has already been disbursed to some people. But here in this case,
Section
section 37, your lordship.
37.
37.
Of what?
37 of Land Acquisition Act, subclause 3.
Hmm.
The collector shall keep open to the public.
Public and display a summary of entire proceeding undertaking in the case of acquisition, including the amount of compensation awarded to each individual along with details of the land final record and the. This is only your case.
Yes, your lordship.
This is your only case.
And as per the Land Acquisition Manual
Is it
2020.
your only case here by this writ petition?
No, as per the manual, Land Acquisition Manual 2022, which also says that when there is a land acquisition process, land owners should be made party along with the HODs of the department. And if possible, there should be a videography and photography of the entire. But in this case, we are contending that we have not been made party. We don't know how much our land has been acquired. What is the quantum?
Land counsel for the petitioner. Petitioners, how many petitioners?
18 petitioners, sir.
By filing this writ petition, the petitioners have sought for a direction to disclose the complete details of the award with regard to the 123.5 kilometer Lada to Lada Surly Frontier Highway Project within bracket package -2, comma 4 and 5. And also challenges the order dated 02/04/2025 passed by the Deputy Commissioner SEPA. What it is? Page 120.
Page 124, yes.
What does it say?
124, Your Lordship.
What does it say?
May I read, Your Lordship? The type copy is in 125. Whereas direction from the Honorable High Court, Itanagar Permanent Bench, UPR, to consider the representation dated 10/2/2025 from Sunday Babang, Sri Tayo Bagang, has been received. And whereas upon careful examination of the aforesaid representation dated 10/2/2025, reliefs in representation are addressed as follows. Conduct a comprehensive physical verification at the ground level of package 5, Lada Sali Frontier Highway. It may be noted that re-verification exercise was undertaken as per order so-and-so dated 06/01/2025, wherein officials comprising land, forest, agriculture department physically verify the entire state of
Whereby the representation dated 10/02/2025 filed by the petitioners. Were you a petitioner in the earlier?
Yes, Your Lordship. We are the petitioner.
Pursuant to the order dated 10/02/2025 passed by this court in WPC
98/2025.
98/2025.
Yes, sir. Whereas
Mr. Issue notice returnable by 4 weeks. As Mr. N. Ratan, London Additional Advocate General, and Mr. M. Kato, London DSJ, enters and accepts notice on behalf of all the respondents.
Yes.
No
Yes,
formal
Madam.
notice. All the respondents.
I will be for
Both
1 to
of
4.
you.
Yes.
No formal notice meet with so and so, so and so. That's
I have blush.
Problem.
Sir, what is this?
My lord, this writ petition filed for impin order being passed by ADC, the upper region, my lord. Directed me to pay sum of rupees 1 lakh, my lord. Which
Heard
he
Mr.
acted
So and
as,
so, Land Council for the petitioner. By filing this writ petition, the petitioner has put to challenge the order dated 10/06/2025 passed by
ADC,
where it is?
the upper region, my lord. Page number 14, my lord.
14.
For page 14, my lord. Annexure 1. Page number 14, my lord. Whereas, my lord, he has no jurisdiction to pass decree order.
Whereby the petitioner.
May I, my lordship, this petition is not maintainable, my lordship,
Why?
because execution petition, it can be done by ADC and DC, my lordship. Yes,
No, my lord. After separation of judiciary,
I have the amendment copy, my lord.
Then we'll consider. We'll see. We'll keep the maintainability issue open and we'll issue notice. That's all.
my lord, notice may be issued until then, my lord, this interim order may be, my lord, stayed, my lord.
No, my lordship.
Then we'll hear you.
Other, my lord,
At 2, we'll hear you.
my lord. Much.
Well, on my part, I have already made a submission.
I forgot.
Previous mistake.
Appointment under sports quota.
Okay.
Recruitment. His case, Mr. Taras' case was that the seal of the secretary was not there, although the sign was there. That was the only ground for rejection.
Affidavit was filed by the concerned secretary that mistakenly I have not put the seal. But signature has been, signature is mine.
We'll continue at 2.
Correct.
All the orders. All the orders.
May I, Lordship?
Favorite service report in respect of the number list after 4 weeks. MS so and so are present. Huh?
What's over?
Well, just, oh, sorry.
Who has mentioned this?
Yesterday, we have mentioned it, Lordship.
For what?
In the last occasion, Lordship, the notice was issued for 1 week, Lordship.
Huh.
So this matter didn't come up, Lordship. What happened, Lordship? In this matter, there is an interim order, Lordship, passed by this honorable court, Lordship. And this IA is only for implement, Lordship, as a respondent, Lordship.
Any objection?
Yes, but just I am entrusted this morning by the client.
No, this is for implement.
Only implement.
Yes, no, objection is there. My client says,
No, who is IA?
Yes, Lordship.
Why is to be implemented?
Lordship, because we are the real owner of this land, Lordship.
Huh.
And we have submitted a numbers of representation to the Deputy Commissioner, and Deputy Commissioner did not consider it. Now, Lordship, this implement, Lordship, as a respondent, Lordship, will not prejudice anything to the petitioner, Lordship, because I am not paying for the modification of the interim order also, Lordship.
Where is the interim order?
Yes, Lordship.
There is no interim order.
there is no interim order.
Lord,
just,
there is an interim direction was given by this honorable court.
only
Lordship
for
will
the-
come,
only for
page
the-
number 19, Lordship.
Huh?
Page number
Your
19,
place?
Lordship.
I don't have this.
In IA, Lordship.
19.
19, Lordship.
Are you sure there is an interim?
247.
Yes.
There's no. Okay.
IA, Lordship. In IA.
66.
Lordship. Lordship. In the last paragraph, Lordship will find page number 23, Lordship, the paragraph 8, Lordship. Taking note of the submission of the learned counsel for the parties, it is provided that respondent number 1 to 5 shall make a final survey comprising of responsible officer from the concerned department and authority in presence of the petitioner and the village headman to submit a report before this court within 2 weeks from the date of receipt of the certified copy of the order. Further, it is provided till the submission of the said report, no activities shall be carried out beyond the area of 66.6 hectare of acquired land originally owned by the petitioner. That is the projected case of the petitioner, Lordship. Now, Lordship, the implement as a respondent, Lordship, the merit of the case will be decided later on, Lordship. Now, me as a contesting in this red petition, Lordship, what prejudice will cause to the petitioner, Lordship?
You are for petitioner or what?
I am for the respondent, Lordship.
You want to get yourself implemented?
Implemented, Lordship, as a respondent, Lordship.
Well, just I do not know the head and tail of this brief. Mr. Mao was there, and then senior counsel Varvara sir was appearing. At 10:30, the client came and engaged me, Lord, with the power also just signed.
Heard Mr. Tigaram Land Council for the petition. Only prayer of Mr. Titi Tara Land Council for the
private
opposite party oblique writ petitioner.
Writ petitioner.
Further 2 weeks time is granted to file objection.
Lordship, in this case, Lordship, this matter may be come up on 21st, Lordship.
Fine.
Because, Lordship, on the 6th, on the basis of this order passed by this honorable court, Lordship.
Yes, next.
Lordship.
Great.
Yeah, again, what is this? What this IA is for again?
For implementing the stability lordship.
Huh?
This IA is for implement of parties in the IA number 161.
Okay. No objection.
No objection.
No, you are yet to be implemented.
I'm implemented in 172, I understand.
No, 175.
Yes. I filed no current amount.
No, in this IA.
Oh, in
This
this-
IA
in
is
this-
for implement in which theatre? Writ petition.
No, in the revision, they have already been implemented.
Yes.
In this, I have for staying of that WT message. In that case, I have made prayer for implement.
You are
So
up.
there is some, I don't know, kindly see, they approach the.
Lordship, may kindly see the last order of
Board stay. Now, the Honorable Division Bench directed them that this interlocutory application for stay be heard today, and till then the DPC has been kept in abeyance. I think that would be till today. The further orders in the stay application needs to be passed.
Lordship, may see the last order.
Amen. I stay. For all.
For all.
This is against which order?
It appears, my lord,
In another 8 petitions.
Huh?
Another 8 petitions.
Lordship, may see. I filed a writ appeal.
No, we'll implement the.
yes, I may be
Yes,
implemented.
I heard Mr. So-and-so, learned counsel for the petitioner. And Mr. Estafin, learned senior government advocate for opposite party. Next, this is an application for implement of. How many? 60? 9 to
60.
60?
Yes.
61 persons in the connected writ petition being WPC 172 of 20. No, in IA.
In the IA, Lordship.
In
161.
Connected IA 161 of 2025.
172
Yes, sir. Having considered that having considered the submissions and they have not been objected to by the counsel for the opposite party, the respondents, I deem it appropriate to allow this application as the persons sought to be implemented appears to be a necessary part for proper adjudication of the matter. Accordingly, the petitions, the following persons, namely so and so, from which paragraph, which their party here?
In the represent their party, Lord.
Huh?
In the represent their
Here.
In this writ appeal.
IA, sir, this present IA.
Yes. They are from serial number 9 to
From serial number 9, huh?
Yes,
Give
9 to
their
68.
name from serial number 9 to 68.
Yes, Lord.
68 be implemented as respondent number 9 to 68. It is allowed in this program.
Lordship, my prayer is that the stay given by the in the writ appeal that may be extended, Lordship.
Huh?
The stay may be extended till the writ.
We'll hear you. We'll hear
There's
you.
no question of extending. The whole
We'll
petition
hear
is
you.
misconceived, madam.
We'll hear you. We'll hear you.
Yes.
Because what is this? What is the order? It appears the applicants may be allowed to implement the affected parties as private respondent in the interlocutory application on or before the 03 and in the till then the process of handling is DPC is kept in terms of this appeal is then this. This up to 03/07
Lordship.
2025.
Therefore,
27.
This may be extended, Lordship.
No,
because
I cannot extend.
There's
It's
some-
the order of the division bench. I cannot expand. I
Lordship,
cannot
my,
touch it.
Lordship, may kindly see the observation.
Huh.
Para 5. In the interlude, in the
I will hear you at
Yes.
S2.
Yes, Lordship.
नहीं मिला अभी तो नो दिखा रहा था मुझको नहीं गया देखो ये किसका है? ये तो नौका है। No.
कौन सा मेरा टाइम लगेगा लास्ट वीक तो आप दिए हमको पिटीशन कॉपी
यार तुम्हारे से जमीन निकल गया ना हवा आ गया कहाँ गए वो?
हाँ इधर है
वो हाँ
ये मैटर को कब बुलाएगा अभी जो हुआ हाँ नहीं नहीं किसी के नहीं ओ हाँ 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 सब तू हो गया तो ये भी करेगा बोल रहा है अभी कौन
May I please, my lord?
Yes.
My lord, back to the withdraw this matter, since there was an amendment in the Arunachal Pradesh Civil Courts Act. So I was little bit not aware about the amendment of the sections. So there is execution provision, my lord.
Okay.
So I may allowed to withdraw the
Okay.
petition.
Mr. N. Rama, London Council, but the petitioner submits that he may be allowed to withdraw this writ petition. Mr. MS K. Wang, London State Council is present. Accordingly, writ petition stands closed on withdrawal.
Much of it.
Writ petition is.
Yes, my lord, writ petition.
So she is correct.
Yes, my lord, she is correct, because after amendment, it is inserted, that section is inserted, that
Okay.
executive, yes, ADC can execute the decree order, my lord.
Let's continue.
Yes.
Connected.
Yes.
17.
16, 17. Yes, yes.
I thought about 17.
This is 172. What do you want?
Lordship, in this case, I approach division bench.
This
Therefore-
IA 161 is disposed of.
161 not disposed of, Lordship, that is pending.
161 is over. 172
172 is repetition, Lordship.
for
172 is a repetition, 161 is the step petition.
So earlier
25/6. On 25/6, your lordship directed us to implead the parties. But no order of stay was granted. Therefore, we approached the division bench praying for stay, lordship.
So 16, what we have disposed of? 177.
No disposal, lordship. Only we approached the court against not.
No, what we have disposed of? Just
On the
no, impleadment petition application is which one? IA.
impleadment is 177, lordship.
Yes, that's right, that we have disposed
Yes,
of.
yes.
Huh? Then
That was disposed. In 161, lordship, IA 161, on the last occasion, lordship directed us to implead the parties that we have done by this application.
yes.
So,
So we'll have to hear you on 161.
yes, lordship.
We're just impleaded. You will have to give notice to them.
Yes, lordship. I shall issue notice. I shall serve extra copies to them. My only prayer is that by the order of the division bench, lordship,
Then in item 16, huh? You add one more paragraph. The learned counsel for the petitioners to furnish the copy of the IA 161 to the newly implemented respondents. Huh?
no, lordship, may kindly see the order of the division bench, lordship, once. Para 5.
Till today.
Yes, lordship. Para 5. Lordship, this petition I filed because
With the learned single by directed appeals to implement the applicable as program, but the opinions are before this owing to a shortage of time as the matter is proposed to be listed after it, which happens to be just before the vote. Then the entire requisition the 50 seconds is not disturbed. It appears that the appeal may be allowed to implement as per the.
So, the last sentence, the delay may render the entire.
What was the order passed in last in this IA?
In the IA, lordship, only I was directed to file application for impleadment, lordship. No order of stay was granted by that, lordship.
Yes, that we have considered now. So you argue what is your case?
Lordship, the lordship may see.
You want to file some objection in I. Okay. We'll allow them. Yes. In IA,
Lordship, in fact, in the repetition, there was no order for issuing notice to the respondent. Lordship, pass that order to the SL sharp copy to the council. Lordship.
That I have already passed. Yes.
No, lordship, what I say.
Mr. Sharma, learned counsel for the petition. You file an appeal against this order again, huh?
Lordship.
Learned counsel for the applicant in IA 161, huh? In view of the order passed in IA 177, allowing the impleadment as sought by the applicants, the learned counsel for the petition applicants to furnish the requisite copies to the learned counsel for the newly implemented respondent number 9 to 68 during the course of the day. Next para. Mr. Anderson learned counsel to the petitioner. Learned additional advocacy for the state respondent is present. Next para. Well, entering appearance on behalf of respondent newly implemented respondent number 6. 9 to 68. Mr. Deepang learned counsel submits that he may be granted week's time to file appropriate objection to the IA interlocutory application seeking stay of the DPC. Seeking stay of the DPC, the stay of the WT message 56 of 2024 issued by the IGP within bracket the ADMN, bracket close, Itanagar. The process of whereby whereby No, thereby stopping the process of holding DPC. Mr. Praise the Lord. The counsel for the newly employed sponsors to file objection to the IA within 1 week, within a week.
Lordship, hence there is an observation that the delay may render.
It is made clear that although next para, the division bench, by the order dated so 3006/2025 in W8 222/2025, while disposing of the matter, disposing of the writ appeal, has observed that learned single judge by an order dated 25/06/2020 indicating the applicants to implead the affected parties as private respondents and allow the you just said learned single judge has observed that while disposing of the writ appeal, while observing that while disposing has observed that in terms of, as per the order dated 25/06/2025 passed by this court, has allowed the applicant to implead the affected parties as private respondents in the present application on or before 03/07/2025. And until then, the process of holding of DPC is kept in abeyance. And process of till then, the process of till then the conduct of DPC be kept in abeyance. Mr. Today, on the application IA number so and so has been disposed of along and has allowed the implement has allowed the implement of the respondent numbers 8, 9 to 68. Mr. Having considered and in view of the fact that the respondents be allowed has been allowed to file objection to the present IA, and considering that the DPC, the process of DPC normally should not be stalled. The no interim order is called for at this stage. Just after a week.
Only thing is that there is a.
By keeping it pending, let them file objection. Division bench has stayed kept it abeyance till today.
With the observation that the delay may render the entire petition infructuous if the process of holding DPC is not stayed, Lordship.
That is your submission.
That is no, Lordship. It is the observation of the court.
Then we'll say in the considered view of this court, the writ petition privacy would not be rendered infructuous even if the DPC is allowed to proceed, allowed to be conducted. We'll add that. We'll add that.
Yes, Lord.
Then your IA become infructuous virtually.
Let them file their objection, Lordship.
That's what I'm saying.
This, Lordship, this may not be.
Huh?
This sentence may not be there, Lordship.
Then,
That's it.
if you want, we'll
Yes,
flag
sir.
that. Okay. Okay, we'll see.
Lordship,
I'm not in favor of
on the next
installing the process of deposition.
on the next Lordship may heard the answer and maybe dispose of, Lordship.
You
If-
tell us whether the last line should be
No,
there
no,
or not.
Lordship.
In the writ petition, my lord,
Hmm.
my lord, we issue notice to us. He is saying we have not been issued notice, and let them serve a copy of the amended
I shall
petition.
serve it, Lordship, by tomorrow, Lordship.
Okay.
Amended petition,
In the writ petition, huh?
172.
172. You write hard so and so, so and so. You have already entered appearance.
I have entered in the pen.
Three of
Serve a
them
copy
you
of
just said.
the-
For all the
Yes, yes.
private respondents.
Mr. Arthur learned counsel for the petitioner to serve the copy of requisite extra copies of the amended
Amended.
writ petition to the learned counsel for the respondents
Yes, Lordship.
Okay.
within 2 days.
Object.
9 and 10. We'll complete the, Mr. Thara, we'll complete the orders first.
Fine, man.
The order matters will complete them. Let us complete.
The long pending matter, but they filed an IA.
For what?
Yes, Your Lordship. Your Lordship, IAS with regards to grant interim protection, Your Lordship. Wherein this petitioner, they are collecting illegal funds, Your Lordship, from various areas, Your Lordship. Petitioner, Your Lordship. Your Lordship, the main writ petition, which is 432, Your Lordship. I am the respondent number 3. And the petitioner.
This is by you.
Yes, Your Lordship.
You are respondent number 3.
Respondent number 3 in the main petition, writ petition 432. So, Your Lordship, I have filed an IA.
What is the prayer here?
To
At page 9. But I have was furnished a copy today only. Though I have seen the prayer, there's something, my lord, they cannot. But I just think instruction if it's correct or correct.
Yes, we'll allow them to file a.
They're saying we're collecting money illegally and all. I have to take instructions.
Meantime, Your Lordship, interim may be passed.
No, we'll just give them a, will consider your IA. Heard, Mr.
Yes, sir.
Learned counsel for the applicant of the respondent number 3.
Yes.
In respondent number 3 in WPC 432 of 2015.
Yes.
And also, no, please stop. This application is filed praying for a direction to restrain the petitioner from using the name of the All Arunachal Pradesh Public Transport Federation within the AAPPTF to collect in order to collect funds and cause public confusion till the final disposal of the connected writ petition. This issue notice as Mr. P. Pang is one. You are one.
1, 2, and 3, Your Lordship.
In the IA.
In the IA also.
P. Pangulan State Council and Mr. D. Pangulan Council for the respondents. Enters appear respondent number 4. Opposite party, number 4 oblique petition, writ petition enters appearance and accepts notice on behalf of the no problem notice. It's just issue notice. On the next date, before the next date, the land council to the respondents, opposite parties may file their, if any.
All writ petition can be disposed of it.
15 minutes. You just file it if you want. I say so I may file if any. List after 3 weeks.
Well,
May it please your lordship.
Yes.
So in this matter, otherwise the parties are represented. So this is the issue.
No, this court orders no taking, no hearing.
No, sir.
But it's complete, pleadings are complete.
Pleadings, sir, otherwise the affidavit has been filed by the respondent.
Hmm.
In fact, what has been given in the respondent's affidavit clears the entire dispute.
Yes.
Now, the entire issue was regarding this is a MZ NREGA supply.
It is listed for orders, what for?
No, sir, there was no stay order granted,
That's
and this
right.
is a supply. And now in the affidavit, it is seen that they have also entered in the contract. So tomorrow they will issue the supply order, and thereafter everything will become infructuous. I was L1.
No, today it's not possible.
Lordship will just hear me on one point.
No.
Because there's only one
This
small.
is listed for orders, sir.
That is true, Lordship. But then the urgency of the matter demands that I may place this before your Lordship.
Yes.
Because otherwise, what happens is, if the supply is done, matter becomes infructuous, Lordship.
Why this has been listed for orders today?
Because for the service. And he is appearing.
I'm appearing for the first time at number 20, my lord.
Obviously, that's why I'm saying, there's
Yes.
no use hearing.
Yes.
You will say today he's appearing and should be given a chance to file affidavit.
That is true.
I'm appearing. But finally is also.
We'll list on immediately day of me.
My lord.
Service complete.
21st.
Heard Mr. A.K. Sir.
A. Sharma.
Counsel for the petitioner in both the reports.
No, my lord.
In, I don't know, 20. I'm praying for a status quo. Or not, let them not move.
21.
And Mr. Titi Thara for, you just give the 2021, huh? In writ petition, sir. And Mr. Also have Mr. B. Picha, standing counsel for role development department, who submits that he has already filed the affidavit on behalf of the department, responding departments, Mr. El Tagum, T. Tagum, learned counsel for the learned counsel enters the appearance on behalf of respondent member.
5 in at number 20, my lord.
5 in WPC 272 of 2020 and 6 in
No, my lord, at number 21, I think service not complete.
you are not appearing.
I'm not, my lord, this. I'm
In
not-
20, at number 20, service is complete. An affidavit has been filed by the department.
21
Whatever
service not
21.
complete, sir. 21 also we have filed, but upon the private respondent service is not complete.
That's why in writ petitions 272 2025.
Take dusty as well.
Mr. D. It's a service is complete. Mr. Tagu prays for and is granted for the 2 weeks time to file the affidavit in opposition. Please stop. You want to take press
Dusty.
steps
Press step, dusty, I'll take.
since
My lord, it's item
service in
number,
respect of restaurant row in WPC 267 of 2025. Come on, Mr. Mr. Kitty Tara, the council for the police. 2 weeks time is granted, 1 week time is granted to take press steps.
Lordship will fix it on 21st.
Number 6, for service of notice of.
I will only see dusty. Dusty.
By of dusty. Please on 20.
On 21st, Lordship, on reopening.
21st.
Declare, oblige, sir.
No, it should be before that bench.
Well, I'm told, court number 1 have, court number 2 have difficulties on.
It's not difficult. Rather, this court is having difficulty. It is to the, that will, I mean, upset the, I mean,
Then, madam,
list before court number 2. List before appropriate bench.
but may I pray that, my lord, since mention has been made this morning, my lord,
No, I don't know. Whether this, I
Look,
didn't
may I
know
pray
there's
that,
a second. appeal.
this can be immediately transmitted to the, my lord, so that only for the issuance of the notice.
Tomorrow. List before the appropriate bench.
My lord. Develop.
Well, I have made exhaustive argument a day. My case is very simple. The petitioner is a nationally recognized carom player. Then there was a advertisement for the sports quota for recruitment of constable in the Arunachal Pradesh police. Then he was invited. Then he qualified the physical efficiency test and physical standard test. But surprisingly, he was not allowed to appear for the written examination. He was not allowed to appear written examination, saying that the form 2 where the secretary of the state sports association recommends does not bear any seal, my lord. So therefore, that was the ground that I was not allowed to appear, my lord. So, my lord, this is trivial in nature, and in my rejoinder, my lord, the concerned secretary has given a certification saying that I have the signature contained in the form number 2 is genuine, but I have not put the seal, my lord. But at the same time, my lord will appreciate that in their advertisement, no whisper has been made about the seal being used except for the signature in physical formula. So, my lord, this I have relied upon the judgment of Vasist Narayan Kumar as 2024 SSC online. For trivial mistake, one should not be punished. And if I recapitulate, my lord, kindly do not punish this boy. At least let him sit for the written examination.
What's the form?
Form, my lord.
Form required the seal.
Yes, ma'am. But my lord, kindly come to page 23 of the affidavit in opposition by respondent number 3. Lord.
You have not annexed the form.
I No, my lord, I have not annexed it.
Affidavit.
Affidavit in opposition by respondent number 3, my lord. Page 22.
Instead of getting it obtained, instead of you obtain subsequent the filing of affidavit, why didn't you place before this certificate before the authority? Have you placed it?
Yes, yes, my lord.
The certificate of
We have
affidavit in what?
affidavit in opposition by government.
464.
Correct.
464.
Correct. Let's find out.
Yes. 464.
Well, my lord will.
Which page?
22 onwards, my lord will say. Well, the contents in the dispute is at page 24, my lord. Designation, my lord.
Name of the petition, national association, address, seal.
Seal.
Seal
But-
is required.
Yes. My lord, kindly see for a moment in the bottom. There is a note. This certificate will be valid only when signed personally by the secretary of the state association, my lord. So, my lord, in my rejoinder, my lord, respectfully, the secretary has given a clarifications.
No, that's why I'm saying, why have not to place this if you had this earlier
Well, that
instead of coming to the court? Where it is? Page 5 of your affidavit.
Correct, my lord. Page 5.
This has been discontinued.
Page 5.
The Arunachal Pradesh Carom Association.
Annexure 1, my lord, page 5.
Four zero 1/20/24. When this affidavit was filed.
Poor fellow, kindly allow. And at least
They filed the affidavit on 14 December 2023, having found that you obtained the certificate on 1st of January, 4th of January.
well, my lord, what to do? The poor fellow has tried his best. At least kindly allow this poor man. It's a very trivial in nature, my lord.
Let me think.
And
Yes.
authorities, my lord, I have relied on
Yes.
that I give.
Para?
My lord, I have relied para 14, 15 to 19.
2024.
SCC online SC2 versus 9, 14, 15 to 19, then 26 and 27. The same thing, the same one, the same fact. The petitioner at that particular point of time was also vying for the
Para?
para, my lord, 14, 15 to 19, 26 and 27. This was allowed. And para 2, my lord, fact is similarly situated.
He has cleared written and physical
Yes, my lord.
eligibility test.
In my case, my lord,
And
I have.
is from a downtrodden segment of the society.
Correct, my lord.
And a reserve category.
Correct. I also
This
comes
is
under
not reserve category, this is sports quota.
sports quota. I also comes under ST, you know. Kindly see, you know, poor fellow.
We are not impressed with the argument which state that the error was so grave as to constitute wrong or misleading information. We say on the particular place. We say, you read this. We say on the peculiar facts and circumstances of this case, even the state has not chosen to resort to any criminal action, clearly implying that even they did not, as having fallen on the fall of the.
Here to date of birth, my lord, was wrongly written. In my case, though, it is very. My case stands better foundation than this.
What you have cleared, you have not been allowed to sit in the written examination, right?
No, my lord, I'm not. Under
what stage you have been rejected?
My lord, I have passed both physical efficiency test and physical standard test, my lord. Then they used to have a viva voice, my lord, interactions.
My lord, that is not the correct.
I said that.
He was not allowed to participate in the physical efficiency test or physical this standard test. He was rejected in the scrutiny of documents.
No. After scrutiny, my lord will see that.
No, after scrutiny in the sense, nothing. You have not qualified anything. Is not it?
My lord, first the scrutiny of documents was to be done.
Yes.
Then
Physical test.
Physical standard test and
Then
physical
the
efficiency test.
Written.
Yeah.
So what has he been?
No, my lord.
That is the problem. Here is a case. What basis? Basis Narayan.
Yes.
He has cleared the written examination, physical test, then only, and in the mistake of mistake in the date of
Correct,
Right.
date of birth only. Yeah,
Your case is
just seal was not there.
seal was not there. And
This
the
is trivial in nature.
requirement is the seal.
No, my lord.
Seal and signature.
No, my
The
lord.
form indicates.
No, my lord. The form indicates, but then in the note below also they have written valid physically signed.
Huh?
The sign.
It has to be signed. It has to be sealed. It has to be
No.
as per the form.
My lord will kindly see. The
And then it has to be signed.
Yeah, my lord, kindly
Otherwise, it would not be valid.
No, my lord, kindly see the bottom, the note. It is
Yes,
physically.
yes. Page 23.
Yes. And even in their advertisement also, my lord, kindly see, even in their advertisement also, putting of a seal is not a mandatory condition. My lord.
This certificate will be valid only when signed personally by the Secretary, National Federation or National Association. What do you mean by that?
National Federation means, my lord, for example,
This
the
is not
football-
Arunachal Pradesh Carom Association. It's not a national federation.
No, my lord, state. Because All India Carom Federation, its affiliation body in the state is Arunachal Pradesh Carom Board.
Let's
Carom
say
Board.
personally by the Secretary, National Secretary of the Association नहीं बोल रहा ना?
नहीं मतलब आप नीचे
It says
मतलब kindly come to page
National Federation.
मतलब kindly come to page
National Association.
24.
Yours is State Association.
Yes, well, kindly come to 24. My thing clears 24. 24 of my rejoinder. Their affidavit in opposition. Page 24 says, note this certificate will be valid only when signed personally by the Secretary of the State Association.
Where it is?
Well, page 24 of their affidavit in opposition by the respondent number 3.
Which one is applicable?
First one is for the national, my lord. The first page,
Okay.
page 23, which my lord is referring is for the national sports
Okay.
person, international sports person. And then page 24 is for the state.
Page 22 is Form 1. That is for
So this is, for him, it's a form 2.
yes.
Yes.
This
my-
certificate will be on the personally by the Secretary of the State. Okay.
Other day, my lord, that's why I made a submission on this.
Form 3 is for university.
Okay. So you are a national player.
State player. I represented state in national, my lord. And I kindly this poor fellow deserves to be.
Yes.
But only the seal part. That is the
So
only.
what do you say?
Now, but in any case, he will have to pass the physical efficiency test and
No,
physical.
if we allow, it cannot be allowed to avoid, obviously.
Correct.
Yes.
They may be called for interview.
I'm ready to do that. I'm
The
ready.
problem is will there be any post now?
A post is there. There was a stay order in his read petition and all those posts were reserved. Okay.
37 for.
37,
Hmm.
kept reserved.
Where is the stay?
I am for 214.
This one. Oh. It's mistake. By
This,
order dated.
This has filed in IA for vacation of earlier interim. I number 214.
By whom? Filed by whom?
By
State.
state, we filed and there was a interim order.
Hmm.
Not to go ahead with the selection process, my lord.
Hmm.
That we filed an IA
Hmm.
saying that altogether there were 98 posts.
Hmm.
The writ petitioners are
Yes.
36 in number.
My lord, by order dated 12/7/2023. Yes, they are. No.
The writ petitioners are 36 in numbers. And
Read petition, yeah,
Okay.
320.
Okay.
My lord, the original stay was passed in read petition number 320.
of 2023 by order dated 12/7/2023. And thereafter, IA was filed by the state for alteration and modification because there were
There were altogether 98 posts. madam.
98 posts.
Writ petitioners, those who are agitating, they were 36. And as far as the select list also, there were 35 only who were selected. So despite, even if the stay remains, the vacancy will not be exhausted.
Yes, absolutely. Then
He will submit.
yours is on what ground? Rejection?
My lord, my case is different from the item number 9. My lord, just for the
320.
purpose of assisting this honorable court, my lord. The case of the petitioner herein is, the petitioner is just praying for the allowing in the recruitment process, not for the appointment of job. My lord,
No, what is the rejection? How you were, on what ground you have been rejected? Say, Mr. Tara's case, it is rejected of having not.
Yes, my lord.
My form 2, it doesn't have the seal.
Yes, my
Of
lord.
the secretary. Simple. Yours
Yes.
is on what ground?
My rejection ground is that the certificate which I have submitted before the authority is of open championship. That is the only ground that my candidature has been rejected.
So what is the requirement?
My lord,
As per the
before,
advertisement or as per the guidelines or rules?
yes, my lord. There was an advertisement on 2018 whereby it is clearly written that page number 43
Of writ petition?
of writ petition. my lord. Point number 6, last part, selection procedure. Whereby it is written that scrutiny of documents. The shortlisted candidates whose application documents are found in order in all respect and call letters issued shall have to produce original document for verification and authentication and on date and venue intimated in the admit card call letter. This was issued in the advertisement. Accordingly, my document have been scrutinized prior to issuance of the
We see the candidates failing to produce original and what?
original document, which I have already.
It's incomplete. It's incomplete, it's not it.
Yes, my lord.
The candidates failing to produce within bracket.
Yes, candidate to file.
Original and what? Next page is something different. This is the advertisement.
Advertisement. I'm relying on the document submitted by the statement. Point number 6, my lord, this is the candidates failing to produce original and authentic documents during scrutiny shall be rejected, my lord. Here, my lord.
It's not in the court's record, it's not like that.
My lord, I am relying on the documents submitted by the state, my lord, in their affidavit, my lord.
No, this is your documents.
Yes, my lord,
Next this.
that part just during Xerox process might be.
It's very difficult to go here and there. Anyway, what you are trying to show?
My lord, the original document that I have already submitted during my filing of the form. That part is, my lord, over. My scrutiny has been already scrutinized by the concerned authorities and call letter has been accordingly issued to me. During what happened, my lord, during the recruitment process there at PTC Bandardua, I just have to produce the original document which I have already submitted before the authorities. And authorities has already scrutinized that document and found in order, whereby I have been issued a call letter, my lord. only that documents, the original of that documents.
So why the original documents has to be submitted along with the application? When you are to produce the documents,
Yes, my lord, during the filing of form fill-up, it was online form fill-up. So I have submitted.
it's online.
Yes, my lord.
How can you give the original?
No, my lord, original was supposed to produce before the authorities there during the PST and
Yes.
PET.
Yes.
That original only, which I have already submitted, and that paper has already been scrutinized, and my name has been listed in selected.
That's why I'm asking, what's the ground of your rejection? Tell us.
Yes, my lord. But however, during course of recruitment process, I was only told that you have been rejected, you have been barred from participation in the PST and PET test, my lord. Only because that I have submitted the Open Championship certificate, my lord.
Tell us, where's
But-
your certificate?
My lord.
Open Championship?
Certificate, my lord.
Where it is? You have been just informed. There's no order as such.
Yes, order they have just given a slip, my lord, rejection slip. But
Nothing
I have-
else.
Yes, I have annexed.
Nothing else.
No, my lord.
Huh?
No, my lord.
Only rejection slip.
Only rejection slip.
When you were called for physical test.
At Bandar, my lord.
Physical test.
Yes, my lord.
First physical test, then written examination.
No, there is no written exam, just physical test and PET, physical efficiency test, physical standard test and physical efficiency test, madam.
Then
After that, the medical examination, madam. Then appointment, madam. This is the.
Is it so? No written examination is required.
As per the advertisement.
Yes, there's nothing. So your rejection is on the basis of the certificate being of open championship?
Yes, my lord.
Not for national, state, international or university?
Yes, my lord.
Yes.
But my lord.
See the guidelines? What rule says? Rules or guidelines? Rules or
Guidelines.
Let us see.
We have annexed, my lord, in our affidavit.
Affidavit in 320.
320, my lord. We have filed two affidavits here, my lord.
One is 320.
320 and additional affidavit in 320 also.
320
also, we have filed additional affidavit also.
So
But
which
it's affidavit dated 8/9/2023.
that additional affidavit?
No, my lord. The first affidavit.
By first is
by respondent number 3 and 4.
3 and 4. Page?
Page 11 onwards, my lord. Annexure 1.
You have typed it out.
Yes, my lord. Type copy is at page 12.
Appointment manager response to
Yes,
group
my
C and C, general scheme. Yes, then
These are continuation. My lord will come to page 14. This will
you just give the type copy. Come to the type copy.
type copy page 18. My lord.
Yes.
Eligibility, my lord. First,
Yes, appointments under the orders can be made of sports considered merits
with reference to the following criteria. Sportsman,
represent state or the
have-
contempt national or international companies, any of the game sports mentioned. Sports were represented in university and international. Those who have visited the state schools. Yes.
my lord. From this, what is that, my lord? In international events, you will have to represent the country, my lord. You will have to be selected from the country, or from the whole over of the country, and then represent in the international forum the country. Then number 2 is the university. in the competition of inter-universities, you will have to represent your university. Then the sportsmen, state school teams.
In national sports games.
Yes, national sports games.
National awards in physical efficiency and the national physical efficiency. This is not required. This is not important. So forget about 4, huh?
Yes.
One is for state or national.
State or country. You'll have to, if there is a
represent the state
or
the country.
If there is a competition amongst the state,
national or international.
yes.
Then university.
Yes.
Then school teams.
Yes. If there is a competition
So
amongst the schools.
their sports or games. What is their games and sports?
They are different categories, my lord. They are in the name of international, but they are on invitation. It's not that there is a competition within the state.
Representing the state or the country.
Yes.
Yours may be international.
Yes, my lord, international or national.
There may be international or national, but they are
It's
not
an
in the
open
capacity.
championship.
Yes, they are not in the capacity of representing the state.
So it will fall under subclause 1. You are
Yes, my lord.
claiming under
Yes,
subclause 1.
yes, my lord. My category falls under subclause 1 of the recruitment rule. However, in this rules also there is no any specific mention about that the certificate from open and championship shall not be considered.
Sir, look at this. 1, that's why you read it.
Yes, my lord.
The certificate,
sportsman.
you are international and national.
Yes, my lord.
National and international certificate.
National and
You read
international.
this.
Yes. The sportsmen who have represented a state or the country in national or international competition in any games sport mentioned in Annexure 1, man. Now, Annexure 1, I have qualified. I am from karate discipline, man.
Yes. No
And-
issue.
And
But
there is
you have to sports is and the games is not an dispute.
yes, my lord.
Dispute is whether you represented the state or country.
Yes, my lord. I have represented state as well as some has represented the state in a national in international forum, my lord. And I have already annexed my document. My lord, for the instance of this honorable court, my lord, in many occasions, the same certificates possessed by the other candidate, they have been appointed in the police department also, my lord.
No, that we are not.
My lord, I have already,
If the wrong is committed, we cannot
my lord, for that I have already filed affidavit.
allowed to perpetuate it.
My lord, even in police department, my lord, same certificate.
It's all right. This may be wrong.
But my lord, they are,
See, are you saying that your certificate falls under this?
yes, my lord.
Why? How?
My lord, I have, my lord, my certificate is very clear, my lord.
You saw as the
Yes, my lord.
while attending or participating in that, you have represented the state or the national.
Yes, my lord.
So what's that?
My lord, page number 41 onward, 46 onward, my lord,
Of what?
of my main petition.
Just wait. Let us complete her thing. Then additional affidavit is what?
Yes, sir, to bring record.
Yes.
Into records.
Additional
Additional,
affidavit is
the individual records, how it was rejected, madam.
okay. Additional affidavit.
The individual grounds for rejection.
Just show us how you were rejected.
My lord, it starts from page 7, my lord. Page 7, annexure 1 series in the additional affidavit. By handwriting, my lord, it is on the spot, my lord, after scrutiny of the documents, after verifying. Disqualified. It's submitted documents.
Para?
My lord, in page 7, my lord, of the
In page 6, they have paragraph 3, they have stated
In
clearly.
the affidavit.
Yes.
Huh?
In
Yes,
affidavit, page
additional
number
affidavit.
3,
additional affidavit.
There are so many affidavits. Copy details of each candidate's rejection.
Yes.
Para 3, they have clearly.
Para
said.
3.
Yes.
The deponents will stay submitted document invitational open tournament.
Open tournament.
Hmm.
There are certain tournaments organized where players are being invited to come and participate. These are the petitioners who go on invitation. The names are international, national, but it is not that they have been selected. There is a competition within the state, and they have been.
For example, page 28.
Yes.
First state level karate do championship. So how you have scrutinized this? State 11 state level karate do championship, certificate of merit. It all mentioned state level,
Yes. It all says state level, even international level, all says, but these are not calendar events under the of sports. For the state or
calendar event is not required, whether you have represented the
Yes,
state
madam.
or the country, that is the
Yes.
Yes, my lord.
They have participated, but they have been invited. And these are tournaments organized by different organizations, federations. But
to represent the state or country.
my lord, to represent, no, my lord, it is a tournament. It's not for representing any state or country, but the players are invited.
But then why this state level and all these things are
My lord,
certificate?
here, sports persons, my lord, the emphasis is, the objective is those who amongst the state, they are being selected, and then they are sent to represent the state. For example, if there is a state for Subrata Cup football tournament is there, then Arunachal team will be selected from all Arunachal. That those players who will represent the state in the Subrata Cup. Likewise, other sports, my lord, they will be selected within the state level and then sent to represent the state. Now, for the country also, entire country, they for football or any other sports, players are being selected to especially represent the country. Now, a person hailing from Arunachal, if he plays football in the international level, but he is not representing, he will not representing the state or the country. He will not be entitled. It is that he has to represent. He has to be sent from the state or from the country. Likewise, from the university to represent the university, from school to represent the school. There are many tournaments organized where players are being called to participate.
Participate to represent the state?
No, madam. To participate in the game.
So this sportsman doesn't have any value in that case?
No, madam. They are on invitation. They are being asked to participate, madam. While participating, obviously, it is addressed that they are from this state. But it is not a case that the state has sent them.
No, my lord. That is. There is no any specific guidelines, my lord, in the Department of Sports and Youth appears to show that this certificate and this sports person has been invited. My lord, and secondly, my lord, all these matters will come later, my lord. The first issue is to discuss, decide by this honorable court is that, my lord, on 28/7/2026, my lord, my page number 77. The page number 177 of writ petition.
No, issue is how, whether your
Yes, my lord.
election is valid or not, that's all.
Yes, my lord, I will come.
So what they are
My
saying
lord.
is, your certificate, you did not represent
No, my
the
lord.
state or the country or the school.
Yes.
Therefore, your certificate will be issued on invitation
Yes,
or
my lord.
open championship.
Yes, my
So
lord.
as per the guidelines, this cannot be
Yes.
valid, this cannot be considered for the
Yes,
sports
my lord.
quota, that's all.
They have taken this decision on the basis of the letter issued by the Department of Youth, Sports and Youth Affairs, why dated 28 July 2011 March 2022 only, my lord. But prior to that, there was one same letter whereby the discipline of these sports has been accepted by letter 28/7/2016, my lord. On strength of that letter, many sports person of same discipline has been absorbed in job, madam. Page number 177, madam.
177.
177, madam.
Selection of managers. I am to inform you that the following criteria may be applied for selection for the student quota. This first provision will be given to the notice. Yes.
177, madam. On strength of this letter issued by the Department of Sports and Youth Affairs, the Home Department, they have appointed the candidate possess the same certificate that I have possessed. My lord, that I have filed in my affidavit, additional affidavit, in phase number.
This is a communication between Director of Sports and the Superintendent Engineer, 2016.
Yes, my lord.
Guidelines in of which year?
My lord, after issuance of advertisement 2018, they have issued the letter stating that the discipline of these sports shall not be, may not be considered, even shall not word not has been used, may not be considered, my lord. But till the filing of this post by the candidate, but by the petitioner, the letter dated letter issued on 2016 was in force, my lord. So my case.
Letter. What about this thing? What about the guidelines when it was issued?
My lord,
2000.
guidelines, there are series of guidelines, my lord, right from 1980, my lord.
Which guidelines applies to this?
2000.
95, 99.
And now, my lord, state has already on its own sports policy, 2017, my lord.
2017.
2017. I have annexed, my lord.
What does it say?
It says 10% of the.
It's only for quota.
Yes.
How to select the procedure criteria, that is the issue here.
Yes.
2001
My lord, first, my lord has already seen that 1988 guidelines, my lord, 80 guidelines. Then at page 31, the preference, how it correct. Here it will be more clear, my lord.
Which one? Which?
Our affidavit, my lord.
Preference.
Page 31.
Yes, my lord. This is in continuation of the 1980 guidelines.
This first one which we have seen is 1980.
80 eligibility, the this categories
21 of
yes,
memorandum.
of national,
95.
state and country. Then 31 is the page 31. This is the preference, how the preference will be given.
Then
In order to facilitate proper selection of sports person, it has been decided that sports person who fulfill the eligibility criteria laid down in para 1 of the department OM dated so and so referred to above shall be considered in the following order of preference. First preference to those candidates who have
no, it's
represented.
okay. Note 4, page 32.
Yes.
In case of any doubt about the status of tournament, the matter will be decided by the Department of Personnel and Training in consultation with the Department of Sports and Youth Affairs.
Yes.
Have you done that?
Yes, madam. Here also it talks about who have represented.
No, in case of doubt about the status
Yes.
of tournament,
Yes,
it's a
yes.
doubt about the tournament. You have
Yes.
doubted. Where is the decision to that effect?
My lord, here the decision, my lord, will kindly see the page 40. Oh, sorry, my lord. I think page 35. Clarification regarding official games.
The journal level is one of the qualifying stages of the competition to a higher level for the national. All India international. All India inter-university school games which can be considered in the match.
The zonal level is one of the qualifying stages of
Just
competition.
clarification, what is this sort of thing?
Qualifying stages of competition for higher level. But what it says about the zonal level? Zonal level means the in the event there is a zonal competition in the Northeast states. The zonal here also zonal level. For example, a football Northeast football tournament.
Whether the sports department is the party here.
Yes,
No.
my lord. Yes, party.
Who has filed this affidavit? Who has filed the affidavit? Whether the
Affidavit is
sports are there?
by respondent number 3 and 4. 3 and 4.
Who is 3 and 4?
The Director General and Inspector General.
No. You'll have to file.
In the event, my lord, yes.
You are segregating your case. Let the sports department to file affidavit.
My lord, on one instance. they
Because
have
it
filed-
said in case of a dispute regarding the status of the tournament, one has to.
Yes, my lord, but my case is.
This has to be taken decision by the personnel with consultation of sports and youth.
Yes, my lord, that is there, but my case is very clear, my lord. My lord,
It's not clear.
my lord,
Sir,
in 2016, my lord, they have already clarified.
thereafter,
And
the
yes, thereafter, in
they have
the,
clarified
yes,
again 2020.
no, my lord, after filing of, after my call letter was
Phase
issued.
34, see phase 34 and 35 of affidavit.
It is better to segregate his case.
No, my lord,
Which is-
what I am submitting is, my lord,
Some merit in his case.
my lord,
He has to identify some of the certificates. also.
my candidature has been rejected after my form was submitted and scrutinized.
Obviously, your candidate was rejected after submission
No, my
only,
lord.
after the scrutiny.
My lord, there has been already,
Maybe you have been called, issued a call letters, doesn't make a difference.
but my lord, this
This
2022,
is larger the things has to be issued, deliberated upon, because whether your certificate, that's why I wonder if the sports person, just because you have not shown to have represented, even if you have the certificate of state level, country, national level, it is not recognized. This is very unfortunate for the sports person. So I think we need to clarify from the sports and personnel department. As per this thing, page 34 of the next guidelines.
Yes, no.
Page 33 or 34 of affidavit. Can you
my lord, this
take
was
it up?
issued after I was called for interview.
Yes.
And,
It's just
and
a technical.
And my lord is very aware of the fact that the game, the rule cannot be changed while the game is on play, my lord.
There cannot be equality in illegality also.
No, in that case, my lord, in same certificate, there has more than 500 candidates in police department, my lord. They have appointed, my lord, on strength of the clarification issued on 2016, my lord. From same discipline, my lord. Even I can show before, my lord. In my affidavit, my lord, additional affidavit, my lord. Page number 289 also, my lord.
Page 32, page 32.
Yes, ma'am.
In case of any doubt about the status of the tournament, the matter will be decided by the Department of Personnel and Training in consultation with the Department of Sports. Personnel department is there.
No, madam. Personal.
What happens is,
Because we just cannot create a confusion
Yes,
again
ma'am.
by disposing of the matter.
Yes, madam.
It will have a ramification.
Ramification.
well, just assisting, this 1980, 95, these policies were not there in Arunachal. So in 2001, during our time, this was introduced. So then what has happened is that 1995 has notified the eligibility criteria. The sports first.
It's okay. We'll see all this thing.
Then in his case also, I have seen some of the certificate of engineering. That he
You
can-
identify whatever is there, but you are coming on the lump sum. His basic, essentially what he's saying is, since I have already submitted my original documents, and after scrutiny, I have been issued a call letters, and suddenly by slip you have rejected. These are all technical. It doesn't go into root of the matter. We'll have to
But
go.
my lord, my only contention is that the police department, same department, they have considered the same.
Suppose they have considered and irregularly or illegally considered appointed, that cannot be it will not give a right to. Sports department is their party.
Yes, my party.
We'll
Have
file
Mr. Ari learned counsel for the petitioner. Although this matter is tagged with the writ petition, tagged with WPC 464/2023, the grounds of rejection of the petitioners for selection for appointment of constable.
Yes,
All right.
constable.
Constable under the sports quota are different and distinct. Therefore, same is segregated. List of as per the office memorandum, dated 04/05/1995, at note 4, it is provided that in case of any doubt about the status of a tournament, the matter will be decided by the Department of Personnel and Training in consultation with the Department of Sports. Sports list of having considered that having considered that there is no clarification, clear-cut decision with regard to the status of the certificate tournament for which the petitioners have been issued the certificates, it is deemed appropriate to allow the appropriate to direct the sports and youth affairs as well as the personnel is not.
Yes, in consultation, my lord, my respondent 6 to my lord will say.
Directed the respondent, secretary to the
Yes,
sports and youth affairs. Huh?
yes, to file an
To
affidavit
file an affidavit
in consultation.
in consultation with the administrative
Personnel.
Department of Personnel and Training, Government of Arunachal Pradesh. This is a central guideline
This is a,
which you are following.
yeah, yes, my lord.
Adopted in 2001 by our own notification.
Let them file.
Yes,
We'll go to the route and decide. That way, this way, that.
But
Then-
in meantime, my lord, I may be allowed to file additional document in form of.
How many documents?
My lord, there are so many documents.
You file.
My lord, hundreds of documents to show that
In-
the
in
same certificate has been
this
admitted.
item 9, huh? Item 9, we have already segregated. Sorry, item 1, item 8.
Nine.
Nine.
Nine and 10.
What is to be done to
10
9?
is, 10 is.
No, my case is clear, my lord.
Heard Mr. Item 9, huh? Mr. Titi Tara, learned counsel for the parties, the petitioner, and Mr. And also heard Mr. N. Ratan, learned additional advocate for all the respondents, state respondents, no private respondents.
No problem.
Hearing concluded. Order to follow. Order to follow. I'm disposing of his matter.
Item number 9.
Yes.
9.
In item number
Yours, your 10 has been segregated.
Oh, yes.
List after 3 weeks.
Yes, my lord.
In each case, huh? In item 11, you add one list after 3 weeks.
My lord, in item number 10, interim is the interim will continue.
Interim order pass a lesser country.
Deeply obeyed.
Obliged.
You have filed the affidavit.
Yes, Lordship.
Bring on this,
I have served already.
huh?
I have served the copy to the petitioner also.
So what is to be done?
Lordship, yes, of course. Otherwise, page 43 is very clear, Lordship. With the application and then the petitioners, hers is the nearest 15 meters.
Which is this?
Others at least
Page
149.
43.
43, Lordship. Lordship will see petitioner at number 10, Lordship, 15 meters only.
In the RCC building, 15 meters approximately.
Others at least 100, 150, 149, Lordship. Only 1 or 2, Lordship.
Risk for herself also. Risk for herself. It's very risk for herself.
Yes, Lordship. The recent incidents also, Lordship.
What is this? IGGS Government Housing Stadium, Miracle Ground. What do you mean by this?
And Lordship, to all other.
Serial number 9. What you are meaning by that? Miracle Ground.
Lordship, this also a miracle ground, Lordship. And then from 44 onwards, we are showing that we are taking action against them also, others also.
Okay. Did they stay or what?
Yes, Lordship. That's why.
What is to be done in that case?
Petitioner also knew that the matter is fixed today, but Lordship. But then see.
We'll see tomorrow. You inform me what
Lordship.
to do.
Lordship.
Or after the. Nothing
Lordship, let it
nothing
list tomorrow if.
Hmm?
let it list again tomorrow if they by chance can, otherwise, because there is a stay order already, Lordship. It's difficult for
You are
the,
taking initiating action. Are you initiating a
no, because of
action?
the, no, because of the stay order, Lordship, against the petitioner.
But if there is no stay against others,
Yes,
there is no other case pending.
no,
None appears for the petition on call. And then unnecessarily why? On 21st, in that case. Tomorrow is the last working day.
after the objection, Lordship. Lordship.
Mr. MSG at the London Additional Senior Government for the state response is present. Mr. Although this matter has been fixed on the consent of the Land Council for the parties, which non-represent the Land Council for the petitioner is absent today. Mr. Providing a final opportunity to the petitioner, let this matter be listed on 21st.
22nd, Lordship. because
22nd,
21
07/20/25. You insist on that day.
Lordship.
That's why I've recorded.
Lordship.
As a last opportunity, I said.
Yes, Lordship. Much obliged.